welcome you all to the conference, which is organized in the frame of Effective Justice Platform. And before I address a few words to you, I would like to invite Mr. Dean of the faculty, Professor Tomasz Nieborak, to welcome you all and start this event officially. Professor, welcome.
Ladies and gentlemen, dear participants of today's conference, distinguished guests, it's my honor and pleasure to open this conference on effective justice, international and comparative approaches, challenges of digital transformation, and to welcome you at our Faculty of Law Administration, Adam Mickiewicz University, which celebrates its 105th birthday these days. This event is organized by Faculty of Law and Administration, Adam Mickiewicz University, and University of Bologna, Department of Legal Studies. The conference is part of a wider project called Effective Justice, which involves a number of research units from many countries around the world. The conference concerns an extremely important and current problem, effective justice, in perspective of challenges of the digitalization of our everyday life. This process, like artificial intelligence, brings with it many positive aspects, but also challenges, especially when it touches on issues of individual rights and responsibilities, which are the case of criminal proceedings. Proceedings which, with increasing globalization, cross the borders are require international cooperation. This is why it is so important to have a continuous exchange of experience in this area, and conferences such as this are the best place to do it, especially where I bring together representatives from many countries. I'm truly pleased to see that today's conference has attracted such a large number of eminent specialists representing science and practice, both from Poland and abroad. Very welcome to you. Let me emphasize that the faculty member of the Department of Criminal Procedure, headed by Professor Paweł Galiński, carry out innovative research into vital and topical issues, which include those related to broadly understood criminal procedure. Let me also thank all those involved in the organization of today's event, because it is their efforts and engagement that have made the conference possible. And I declare my support for similar initiatives in the future. Many thanks to Professor Barbara Janusz-Pohl and her team, and of course of our friends from University of Bologna. Grazie. I wish you all fruitful discussions, and I hope you have a special time in Poznań. Thank you very much.
Thank you, Professor, for this warm welcoming. And now I would like to ask my dear friend, Dr. Ewa Habry-Chojnacka, who is Vice Dean of the District Board of the Bar in Poznań. So please, Ewa, could you address a few words of welcoming?
Szanowni Państwo, Pani Profesor, w imieniu Wielkopolskiej Izby Adwokackiej chciałabym serdecznie podziękować Pani Profesor Barbarze Janusz-Pohl za zaproszenie na dzisiejszą konferencję i za umożliwienie adwokatom i aplikantom Wielkopolskiej Izby Adwokackiej bezpośredniego w niej udziału. Wielkopolska Izba Adwokacka od lat współpracuje z Wydziałem Prawa i Administracji Uniwersytetu im. Adama Mickiewicza w Poznaniu, realizując wspólne wydarzenia naukowe. Ta ścisła więź pomiędzy praktyką i teorią pozwala na poszerzenie wiedzy prawniczej w wielu dziedzinach prawa, co ma szczególne znaczenie dla jego prawidłowego stosowania. Zagadnienia poruszane podczas dzisiejszej konferencji są niezwykle istotne zarówno dla teoretyków prawa, jak i osób wykonujących zawody prawnicze. Nowe technologie szeroko wkraczają w codzienne życie, zatem procedury sądowe, zarówno cywilne, jak i karne, nie mogą być zamknięte na nowe wyzwania w tym zakresie. Prawo powinno podążać za postępem, bowiem jedynie system prawny, który dostosowany jest do zmieniających się realiów życia, będzie stanowić należytą ochronę prawidłowego funkcjonowania społeczeństwa. Jeszcze raz w imieniu członków Wielkopolskiej Izby Adwokackiej dziękuję za możliwość udziału w tak ważnym wydarzeniu.
translate in short words the welcoming, and Dr. Ewa Chojnacka is very grateful for this collaboration, and she emphasized that the Faculty of Law and Administration has improved contact with the bar in Poznań. So also the members of bar are the alumni of Adam Mickiewicz University. And this project could embraces all people involved in science and also the practitioners, as the challenges to digital transformation are important when it comes to the creation of law and for the practitioners, as well as we might notice, also for the scholars, as we are today struggling with the digital aspect of this conference when it comes to connection with the participants online. In short, Dr. Ewa Chojnacka wishes us fruitful deliberation, fruitful discussion, and good luck for the conference. If I may now address a few words for myself and also then my dear colleague, Professor Daniele Vicoli, will speak on behalf of himself, of Bologna University. So as I welcome you all, I would like to repeat it one more time. So I'm really glad that we achieved to organize this meeting in person, as we struggled a lot with obstacles, and nowadays it's so hard to gather people all together in one place still. If all of you could join us online, if we manage to organize transmission and the streaming. But I think that this direct touch, and I hope that through discussion that followed the presentation might not be replaced just in the digital sphere presence. So let me tell you a bit about the Effective Justice Platform and this project, because this conference is something more than digital platform final conference. As initially we aimed to organize the final conference in the platform, but as far as we agreed, digital platform and effective platform will be performing after this conference, probably under the tutorial of University of Trento, also by the new leader of Dr. Marian Nabiral. So it is not a final conference in the platform. But we started our work in effective justice in December 2021. And during last 2 years, we performed 8 international seminars. We gathered more than 40 scholars and performers to effective justice, achieved to also organize themselves in smaller group of research, and as well perform some scientific and networking scholarships among each others, and also with collaboration with other new guest performers and people who would like to develop their skills in digital justice. So recently we applied also for 2 European grants based on the performance of digital justice platform. But what is the achievement of effective justice season first is a book which is to be published soon. The book is published by Peter Lang, editor, under the title the same as the platform is, so Effective Justice, International and Comparative Approaches, and we will offer you very soon part first edited by Professor Vicoli and part second edited by me. But this conference, as I mentioned, gathered more scholars than only effective justice performers. So as you might observe, agenda covered 41 speeches. Some of them are by effective justice performers, some by the guest performers. So we think that this might be also the next step for the further collaboration. And last but not least, I must mention about the dear colleagues and great scholars who decided to support effective justice platform at the beginning. And the most important person is the Professor Steven Thyman, who is present here, and we'll have a great chance to hear his wonderful opening lecture. But I must mention also two important Italian scholars, Professor Giulio Illuminati, who will be a peer reviewer of our final work in first edition of Effective Justice Platform, as well as Professor Renzo Orlandi, who also brought us together at first. We met due to the contact of Professor Renzo Orlandi, so we could start our collaboration thanks to Professor Renzo. So I hope that next time in these walls of the Faculty of Law, we could host also Professor Renzo Orlandi. So now I'm passing the floor to my dear colleague, Daniele Vicoli. Online transmission has been started, so we are also online.
Dear participants, I'm thrilled to be here at Adam Mickiewicz University and kick off this important conference. First of all, let me thank the Dean of the Faculty and the Director of the Doctoral School, but especially Professor Barbara Janusz-Pohl. We had the chance to know each other in 2021 when I was appointed as a reviewer of one book had been edited by her, and I must admit that no other reviewing activity has been equally fruitful so far. Since then, we have started to collaborate and share projects and research perspectives. But more than that, a close friendship, a very close friendship, has born and grown over the last 3 years. The Effective Justice Project developed from an idea of Professor Barbara Janusz-Pohl, and we are here today. It's thanks to her and her outstanding team, Michał, Adrian, and all the others. I am deeply grateful to all of them for the efforts in the fulfillment of the research project's objectives and also for the warm hospitality here in Poznań. After these due acknowledges, I would like to say just a few words on the project. It covers 5 thematic fields: organization of judicial systems, digitalization, special and abbreviated proceedings, evidence, and remedies. Within these fields, the members of the team have freely developed their research and presented during the periodical seminars. I say freely because as heads of the projects, we decided not to impose specific subjects or methods. Instead, we decided to ensure the greatest leeway to team members. It was a deliberate choice. We decided and we wanted to see where the research carried out by scholars from different countries and backgrounds would have taken us. And today, I can say that it was a very fascinating journey with many people and perspectives involved. The conference, which is about to start, is the occasion to present the results of this journey. And as Professor Barbara Janusz-Pohl told, alongside with the forthcoming publication of 2 books gathering the contribution of all the scholars who have joined and enriched the project. I would like to warmly express my gratitude to all of them with the hope that this conference could be a starting point for further scientific collaboration and partnership. Thank you.
And now, dear all, we have a great pleasure to welcome our really special guest. I must not present Professor Steven Thyman, who is a widely renowned international scholar, so I think that you might know him already, and at least the people who are involved in research probably read some of papers or books by Professor Stephen Taiwan. So I just want to mention that we have a great honor because Professor Taiwan has supported the platform and is still willing to support us in future, I hope. So now I'm giving the floor to Professor, and this opening lecture will cover the recent challenges of especially criminal procedure, as Professor Taiwan is a great specialist in comparative criminal procedure. Thank you, the floor is yours. I will bring you.
Good morning. It's a pleasure to be here. It's my first time in Poznań, and it's great to see old friends that I've met. Pavel Galiński, we met in Vietnam, and Barbara, of course, we met in Lisboa. So we all travel a lot in this field. It's great to do. I really encourage that you study comparative and international law because it makes the world much bigger for you. Well, Barbara Janusz-Pohl, in her paper, suggests looking to the overall goals that the legislator has assigned to the criminal process to find out whether we are being effective or not. And it must relate to both the substantive law and formal or procedural law. Now, continental Europeans and increasingly the US Supreme Court see the search for truth as trumping procedural due process. In other words, if we want to get the truth, we look aside, don't worry about illegally gathered evidence, we don't worry about violations of the right to confrontation. If we can determine the truth, which means normally a conviction, we prefer that. This used to be an inquisitorial principle, but now it's a principle that the United States Supreme Court follows as well. How do we formulate our legislative goals? When I, back in the 90s, was studying Soviet law, the old Soviet codes proclaimed that the goal of criminal procedure was to not let one guilty person go unpunished, nor one innocent person be punished. Now, how do you do that? Well, they did it by convicting 99.9% of everybody that came through the system. This was, of course, a system that claimed that the presumption of innocence was bourgeois drivel. In other words, not something we had to worry about. If the legislature or the law, and this used to be the case in the United States, believe the presumption of innocence, believes that it is better to acquit 10 guilty persons than to convict one innocent person. Now that's what we say in the United States. We used to say in the United States. The great Jewish philosopher Maimonides said it's better to acquit 1,000 guilty people than to convict one innocent person. So this has an old tradition. And so success could be measured by how many people we acquit who might be innocent, because the evidence is weak and we cannot convict them. Most of our legal systems, I've heard now that maybe Italy's different, but I'm not so sure. Most of our legal systems do not acquit very many people at all. Acquittal rates range from 0.1% in Russia, China, Japan, to I'm guessing maybe 5% would be a lot of acquittals. Now maybe Italy has higher than that. I'm not talking about dismissals before you take the case to trial. The United States, even though I tried about 60 jury trials. I got about 50% acquittals, if not more. But those days are over. Now almost every case is forced to plea bargain, so if you include those in, the US acquittal rate is very small as well. Can effectiveness balance the desire to convict the guilty with respecting the guarantees related to the presumption of innocence? And Daniele, Vicoli asked this question, balancing effectiveness with the rights of the defendant. So Germany, for instance, justifies using evidence gathered in violation of its constitution by referring to its homespun constitutional command of having a well-functioning system of criminal justice, which is found in no bills of rights and no human rights conventions, to my knowledge. But their constitutional court and Supreme Court have invented this constitutional idea that we have to have a good, well-functioning criminal justice system. So if the police violate the rights of a defendant and get evidence, if we don't admit that into court, our system won't be functioning well. So that's effectiveness? I don't like that definition of effectiveness. Italy also justifies using illegally gathered evidence or inherently weak evidence, often created in what we call in the States the black box of the police investigation, this secret police investigation which creates evidence, which this would be evidence which the defendant never had a chance to confront, by referring to its own. Italy also has a homegrown constitutional idea of the non-dispersal of evidence, which I found in many decisions. I don't know where they got this, but the idea is if you have a piece of evidence, like maybe a confession that was gathered in violation of the law or statements that were never cross-examined, that has to go into the decision of the court. That is very weak evidence. Once we have a piece of evidence, even of the most unbelievable type, created by the police, it is admissible. And Chiara Gabrielli points to the dangers of basing cases on evidence gathered by often dishonest police and prosecutors. Now, I don't know about your systems, but in the United States, we have a lot of dishonest police and prosecutors, and we know that. But I tend to see that the higher courts in Europe, when I compare case law, they seem to accept police evidence as being inherently true and should be presumed to be true. And this is the evidence that should be subjected to falsification, to challenging more than any other evidence, in my opinion. The defendant's guarantee in these systems oftenly, and you see this in German decisions and in just decisions of the European Court of Human Rights, this is supposed to be a protection of the defendant, that the judge will evaluate in an especially careful manner this bad evidence along with other often bad evidence, and in the totality will explain why they decided to convict. And it's obvious when one reads judgment reasons that the longer the judgment reasons are, sometimes 150 pages, they're usually the weaker the evidence, because they have to spend a lot of time justifying convicting on very weak evidence. Now, the right to a speedy trial, I'm not going to talk so much about that, but it's true that a lot of countries, and apparently Poland, I know Italy had problems with that, have problems with really bringing cases quickly to trial. And I know when I used to teach in Madrid every summer, I had a summer course there, I used to go watch their trials, and they'd have a very simple murder case. You know, a roommate stabbed another roommate, they arrested him. They always brought them to trial 3 or 4 years after the case. And I'm sure they did no other investigation after the arrest. Very slow system, and they're allowed to keep people in pretrial detention for 4 years in Spain. So, now the full criminal trial, and I like the Spanish say with all the guarantees, is time-consuming, expensive, and most governments do not want to provide this gold standard of procedural fairness, which would be synonymous with the notions of due process, or in Germany, Rechtsstaatlichkeit. It is not popular to spend the citizens' tax money on what Americans would see as mollycoddling criminals. By providing them with high-quality defense counsel extensive adversarial rights, to have full disclosure of the state's evidence and challenge its quality, of being able to exclude illegally gathered evidence. You know, the defense is not allowed to illegally gather evidence. Why should the prosecution be allowed to illegally gather evidence by violating citizens' rights? To cross-examine the state's witnesses and insist, where it is available at trial, with participation of members of a jury, like in the United States, or a mixed court, rather than just before a professional judge. You know, obviously I was a defense lawyer for 12 years in the United States, so, and in a time which I call the halcyon years of being a defense lawyer, when the public defender's office where I worked in Oakland, California, we got the same pay as the prosecutors. We had 130 lawyers, 30 professional investigators, and the sentencing system was such that you were not forced to plead guilty. So we had a lot of trials, and a lot of acquittals, because generally, and I think it's true of all of our countries, the investigators are not very good. They usually rely on trying to get a confession, and if they don't get a confession, they don't know how to prove guilt with independent evidence. You may have, the two famous models of criminal procedure, which Herbert Packer wrote about in the 1960s, are the due process model, which I just outlined, a model in which the presumption of innocence and proof beyond a reasonable doubt are the most important principles. And it is preferred to acquit 10 guilty persons rather than convict one innocent. And then the crime control model, which usually gives priority to the search for truth, the guiding principle of inquisitorial criminal procedure, a principle normally not included in human rights conventions, bills of rights, over the presumption of innocence and the other great defense rights, the privilege against self-incrimination, the right to be free of unlawful violations of privacy, the right to be free of coercive interrogation practices, and the right to confront and cross-examine witnesses. The fully adversarial American trial with well-funded and zealous defense counsel, and that was when I was practicing, meticulous jury selection, unanimous verdicts, generous exclusionary rules, and sovereign juries whose acquittal is final, is perhaps the most costly and time-consuming of any system. I tried a death penalty case where it took us 3 months to pick a jury. I mean, it's too complicated in the United States, and that's why the conservatives got rid of it. And I'll tell you how they got rid of the jury system. Well, the actual American system, plea bargaining, made inherently coercive by draconian penalties, which were raised maybe 4 or 5 times since I was practicing. So, which can be used to threaten defendants, guilty or innocent, to waive their adversarial rights and plead guilty. It's turned into, our old adversary system has turned into an administrative system, if not inquisitorial. And if you're threatened with death or 50 years, and they offer you 5 years, I mean, it's almost like torture. And John Langbein has compared our plea bargaining system made it as a substitute for torture. If you can believe it, in 12 years as a public defender, I had never had one client go to prison for drugs. It was I quit in 1987, but in the 80s began Ronald Reagan's war against drugs and fight war against crime, when they started raising punishments. Now drug dealing is considered to be so serious that you're presumed to be in pretrial detention. In those days, even the worst drug seller got no more than 1 year in the county jail as a condition of probation. That's how the system has changed. The inquisitorial administrative judicial inquiry, like you have in Germany and perhaps in Poland as well, is simpler, less cost intensive. It's not really litigation as we see it in the common law. It's more of an official investigation, as it's called. Does not provide for a vigorous role of defense lawyers or strong exclusionary rules, as long as the evidence is relevant to proving the truth of the charges. And it does not let its lay judges, if there are any, acquit with impunity, because you can appeal any acquittal in almost every system. And usually if the prosecutor general in Germany supports overturning the acquittal, the judges will always overturn the acquittal. Although more administrative European systems have complicated multi-levels of appeal, which are time-consuming, one of their main purposes is to control, if not discipline, the lower courts and to overturn acquittals. Seeing the many levels of courts of appeals as a guarantee for the defense is only partially true, I think. Making acquittals final, and I think the US may be one of the only countries that still does that, which puts teeth into the presumption of innocence by not giving the state multiple chances to try to prove its case. Why should the state, with all of its powers of investigation, get to have a dry run in the lower courts and then the prosecutor can appeal? Oh, we didn't like the results of that. Let's try it again. We made our mistakes. We know now how to do it better. This would work as a real savings if you made acquittals final. But no, very, very few courts in the world are willing to do that. Even the Italian Constitutional Court rejected a law that, it didn't make all acquittals final, but rejected it, claiming it violated the constitutional rights of the prosecutor. Where do you find a human rights document that gives rights to the prosecutor? But the Italian courts have found the right of the prosecutor to equality of arms with the defense in appeals. Very strange stuff for a common lawyer. Well, there's many ways to save money, cost effectiveness. One is by saving money by underfunding the criminal defense justice system. Another is by eliminating the full preliminary investigation in civil law countries. Also eliminating the preliminary hearing, or the Zwischenverfahren in Germany, having immediate trial for flagrant offenses, which I think is good. If somebody's caught in the act, why do they have to wait 3 years to have a trial? So that all the bureaucrats can make a big file and type all this stuff into the file. It's really useless. They could bring you to court like in Italy, France, Germany in 15 days, have the trial. Except, some cases might be questionable. Maybe the person wasn't really caught in the act, so you have to be careful. Or it may be a complicated might be a murder and there might be some mental offense. So you can't do it in every case. There are also immediate trials for those who confess to the police. A lot of systems have that. Simplified trials for those who confess in court. That would be like the German system, which used to be called Absprachen and now Verständnis. And full elimination of the trial, which is American plea bargaining and many of its other progeny in Europe, where you have stipulations of guilt with discounts and so on. Now, underfunding the criminal justice system, governments routinely cause the overcrowded court dockets by slashing the budgets for courts, prosecutors' offices, and systems of court-appointed lawyers for the poor, which they then use to justify procedural economy by streamlining the system with expedited, abbreviated, and simplified procedures. Normally delays caused by caseload demands are unacceptable, also by the European Court of Human Rights, and used to be by the US Supreme Court as well, for denying a right to a speedy trial. It was once said, when I was practicing, that the entire federal criminal justice system in the United States costs about the same as the wing on one B-1 intercontinental bomber. But the United States prefers to put all its money into defense and not much into the criminal justice system. And Thomas Piketty has convincingly argued that a mere 1% or 2% wealth tax on all of our richest oligarchs in all of our country would not only finance court systems, but very generous welfare, educational, health, and transportation systems, which of course would then lead to less crime. But nobody wants to tax the rich and pay for things that we really need, like a good justice system. There are excessively cumbersome procedures. I told you the amount of time taken in the old days in California, especially to pick a jury, was ridiculous. the amount of time taken in pedantically questioning every witness before trial and the defendant multiple times insisting on preparing a document for the file with the summary of the testimony, not just taping it, refusing to make the file accessible digitally. Here a digital revolution would really be good. In Germany, the courts refuse to make a copy of the trial. They don't want to know what's really said in the trial. The courts are against that. There's no record of the trial in Germany. It's not considered that important. What's important is what the judge said about what happened in the trial in the judgment reasons. You know, that's, problem in Spain, I spent a lot of time watching Spanish cases, they only work half a day because all the judges go home to write these long-winded opinions. The more long-winded, when they're the less evidence usually. I talked about the refusal to finance effective defense counsel. Due process now requires effective assistance of counsel not only at the trial, but also from the moment of arrest after the Challanges decision by the European Court of Human Rights. But most jurisdictions allow the defendant, of course, to waive these pretrial rights and to be interrogated incognito by the police. Now, Europe generally appoints members of the bar case by case to represent indigent defendants, and it is my understanding, correct me if I'm wrong, that these lawyers are often inexperienced, are not paid very well, and may not be able to be present immediately after arrest because they should have a lawyer right after arrest. Only in the US and Latin America are there public defender offices which potentially can be in the jails at all times to represent the indigent. And England has duty solicitors which do this as well. But the budgets have been slashed for public defender's offices and for appointed counsel in the United States to at times 1/2 of what they were in the 1970s and 80s when I was practicing. At the same time, the budgets for prosecutors and police and mainly for prisons have risen. So they've put the money for prisons, because we have the highest prison population in the history of the world. For a free country, it's a strange idea, but we've moved. In fact, even Arnold Schwarzenegger, when he was governor of California, made a promise. He said, we have to pay now more for schools than we do for prisons. They actually have more money in prisons than in schools. Now, the primordial method from the beginning of criminal procedure for simplifying the trial was, of course, inducing or forcing a confession. The queen of evidence. Once you get them to confess, you don't have to investigate the case and really prove it with independent evidence. And we all know today that many of those who confessed crimes in the good old days of torture were innocent. I've long maintained that the history of criminal procedure has been the history of perfecting or humanizing the procedures of inducing defendants to confess. Getting more clever, plea bargaining and things like that. We don't have to torture them anymore. We have other ways. Keeping them in pretrial detention until they confess, then they get out, things like that. I've already talked about whether a preliminary investigation is necessary, maybe not for flagrant arrests. The trend now for many decades has been to trim back the formal preliminary investigation in Europe and use it mainly for the most serious crimes, such as murder or maybe terrorism. 41% of French cases were investigated by investigating magistrates in the 19th century, and only 3% in 2014, the statistics I have. The Dutch juge d'instruction has gradually been phased out of conducting investigations and now functions mainly as a pretrial control judge. In Spain, which still has the investigating magistrate, most cases proceed pursuant to their abbreviated procedures. So the preliminary investigation, this thorough model, is being phased out. And countries like Italy and Spain, for jury trials at least, have said that the preliminary investigation is not to collect all the evidence for the trial, but only the evidence that can't be reproduced, or sufficient evidence to have probable cause to charge the case. Now, in Japan, a suspect who confesses will normally be released from pretrial detention, and following a substantially simpler trial will usually be sentenced to either credit for time served in pretrial detention or a substantially more mitigated punishment than she would otherwise have gotten had she remained silent and gone to trial. Some people have called this a plea bargaining system. Japanese insist we have no plea bargaining, we don't believe in it, but their system of using pretrial detention to compel people is something like plea bargaining. Now, as I said before, the dramatic rise in punishments has made the American plea bargaining system inherently coercive. And the U.S. Supreme Court, for instance, upheld as early as 1978, a case in which the defendant was offered around 5 years for an $89 theft. But he had a bad criminal record. He refused. He said he wanted a trial. He went to trial and he got life in prison. And the Supreme Court said that doesn't violate due process because he was told that's what would happen if he went to trial. So this, even back in the late 1970s, we already had this okay of the Supreme Court that we can have these extreme differences between minimum and maximum punishments to make our plea bargaining system work. We also have cooperation agreements, which were passed in Russia and many other European countries. And basically the prosecutor says, if you cooperate with me and I say that you did a good job, you can get below the mandatory minimum sentence. And now even innocent people are trying to cooperate with the prosecutor so they will get a punishment of less than the minimum. And the minimums can be 25 years in the United States. There's some serious cases, 10, 15, 25-year mandatory minimum, so extremely coercive. Now, many of your papers, I know the papers of the people in this great project have talked about diversions, dismissals with conditions, victim offender conciliation. These are really great methods for saving money, getting rid of the more or less the less serious cases. Penal orders are used in almost all the European countries now, but they're also mainly restricted to the lesser offenses. In other words, and as long as people are not going to prison, there's no problem in my book of seeing if they want to admit guilt and so on. It's not coercive like the system in the United States is. There's questions about whether the person even knows what the evidence is when they have a penal order. I mean, they never go to court in countries like Germany. It's all on paper. It's really prosecutorial sentences. But as long as it's minor charges, I don't see a big problem with that. You could just decriminalize these kind of charges too. That would be another way of doing it. Take them out of make them administrative offenses or something. But I don't want to take too much time here. You have the German confession bargaining, which really, some of you might know the history of that. There was a lawyer who wrote an article in 1982. He called himself Detlef Deal, which was a pseudonym, and he revealed this procedure that none of the professors knew were happening. The lawyers all knew was happening, and the judges, but John Langbein wrote an article right about this time called Germany, Land Without Plea Bargaining, because nobody knew it was happening. It was all secret. And American plea bargaining was secret too for a while. But originally, I found a case from 1960 in Germany where the defendant was charged with rape. He said he was not guilty. The judge told his lawyer, look, if your client doesn't admit in court, he's going to get the maximum punishment. The defendant said, well, I'm not guilty, I'm not going to admit. And then the judge came back with that. Look, put pressure on the lawyer to get his client to admit in court. or he won't get the maximum. And finally, the defendant admitted in court, this is a Supreme Court case from 1960, the defendant was found guilty and was sentenced to the maximum. And he complained to the Supreme Court. He said, I was forced to plead guilty and I got the maximum sentence. And the Supreme Court said, yep, the judge didn't say he was going to give you anything less. He said the only way you could get less, maybe, would be to admit in court. So you can see this is an inquisitorial roots. The strong German judge pretty much forcing the defendant to admit in court so he wouldn't have to call all these witnesses and prove guilt, and then giving him the maximum anyway. So really, I think these Absprachen, they used to call them, it's probably always been the case in these strong inquisitorial trial systems like Germany, where the judge rules the roost, the lawyers sit back and like potted plants and don't do much. And so it was revealed in the 80s, and now it's, as you all know, it's now part of the Criminal Procedure Code with some guarantees. One important guarantee is you can't make the difference between the maximum and what you might get too big, like in the United States, because that would be seen as coercive. Italy, in their 1988 code, introduced a lot of different procedures to try to accelerate, have speedier trials, and apparently they're not working that well, because the defense lawyers figure out ways to play with the statute of limitations to force dismissals through other means. But you know, if you admit guilt or stipulate to guilt, you have 1/3 off the maximum sentence, or you get 1/3 off the patteggiamento. I actually used the patteggiamento when I was working on the Russian code of 2001. Russia introduced it and then raised it from 3 years up to 10 years and made it very coercive. So these kind of systems, although they seem mild, you get 2 years instead of 3 years. They can be also, by an oppressive regime, can be turned into really coercive mechanisms. Now, finally, what if you avoid both the two classical procedural models? In your classic inquisitorial system, the formal preliminary investigation was where the guarantees of truth-finding were seen to lay. It was the most time-consuming and costly part of the trial. If you read the codes of criminal procedure, 2/3 of them are the preliminary investigation. The trial is usually about 5 pages, so the trial was supposedly the main hearing, but it was procedurally something very not so complicated. And trial was basically a perfunctory review of the preliminary investigation. Still in Holland, they almost never call witnesses. They just have the file and they read the file, and and the defense has to make a big offer of proof to even have a witness be heard in a Dutch trial. I think that's the most old-fashioned of the European systems, I would think. In the classic common law adversarial system, the police investigation was perfunctory. That means, I think in most cases, I recall, most of the investigation was done, if it was a flagrant case, within a day or two of arresting, talking to the witnesses. That's all they did. If it was a complicated whodunit case, they don't know. It took a while to find out who the suspect was and so on. Those are more complicated. And then the trial was very long-winded and costly with all of these rights of the defendant, jury trial, and so on. And it's an irony in the United States, from the time in the 1960s that the U.S. Supreme Court actually became a due process court under Earl Warren, the Chief Justice at that time, who incidentally founded the Alameda County Public Defender's Office that I practiced in California when he was district attorney of Alameda County. But once the trial became more complicated, jury selection became more complicated, you tried to allow maybe some minorities to be on the jury, they changed the law and increased this coercive plea bargaining system, so there are very few jury trials anymore. So once minorities like blacks got full rights, jury trials hardly exist anymore. So it's a bit of a contradiction. Well, what happens if both of those complex, both the trial and the preliminary investigation are eliminated. You don't have either one. If you have a perfunctory or simplified preliminary investigation, then it's a less reliable basis for judicial control once you use these abbreviated plea bargaining type procedures. You don't have much of a file to check, is the person really guilty or not? Can there be truth if there's no complete investigation of the facts, just because the defendant says he's guilty? I won't go into the details, but I liked a German solution. I think they called it the Alternative Entwurf back in the 70s maybe. The idea was to focus on the preliminary investigation, but make it like into an adversarial mini trial where the defense was present during all of the collecting evidence, and only after that have an offer like a penal order. The prosecutor would say, well, I think this case is worth 5 years or something. The defendant say, no, I don't think that's too much. And then I think even Tiedemann suggested having maybe a jury trial afterwards. But really, if the preliminary investigation is completely adversarial, and I think Justyna Globocka talks about this in her paper as well, adversarial, then you've preserved the evidence. The written evidence can be used at trial because there's been a right to confront the witnesses at this preliminary hearing. So I like that idea. I don't know if anybody's talking about it anymore. My conclusion would be civil law jurisdictions are slowly introducing more prosecutorial discretion, opening the door to consensual procedures, mainly in low and mid-level offenses. Civil law jurisdictions usually maintain a moderate to substantial level of judicial and sometimes victim control in excess of what exists in the United States. But if consensual procedures are overwhelmingly successful with fine-only and minor jail offenses like penal orders, diversions, conciliation, why not just decriminalize them? I think I said that already, but just take them out of the criminal justice system instead of making them criminal and just having them dealt with in kind of an administrative fashion. Make them administrative offenses. And if consensual procedures are very successful, like in the United States, we should look to see if maybe they're inherently coercive. That's why they're really successful, because they're coercive. You can't, and people have written that a defendant that refuses a good offer, an innocent defendant is not being wise in the United States by going to trial. I mean, it's a bad decision to go to trial if you're innocent in our particular system. One problem with the innocent who have bad criminal records is if they testify at trial, their whole bad criminal record comes before the jury. So you can imagine somebody that might have done 5 years for molesting a child once in the past is arrested in this little town because who do you arrest after a child is molested? You arrest the guy that's guilty, the guy that committed it before. You try to get him to confess, or you put a jail plant, somebody in the jail that says he confessed. If he gets up and testifies, his prior record comes in. So a lot of our innocent people that are sentenced to long prison terms are these kind of people with bad criminal records who are arrested because they're the usual suspects, and then they're put into this coercive system. If they don't plead guilty, they go to trial, and then they're convicted anyway. But second conclusion, the presumption of innocence can lead to more effective procedure through making it more difficult to convict by introducing negative, and I've suggested this at times, negative rules of evidence. There should be no convictions based on circumstantial evidence unless each circumstance that's necessary to infer guilt is proved beyond a reasonable doubt. This is the instruction in California to jurors. They cannot find anybody guilty unless each circumstance that in the chain that leads to inference is proved beyond a reasonable doubt. The judge must adopt, or the jury, an inference of innocence if there are two inferences. Two reasonable ones. They have to follow the inference of not guilty. There should be no convictions based on the uncorroborated testimony of one witness, eyewitness or other. I think you should make testimony of jailhouse informants, which all those countries use, in weak cases. They don't use them in strong cases. Weak cases, they put somebody, an informant, into the jail cell, and that informant claims the defendant confessed. Maybe he did, maybe he didn't, but this is black box evidence. I think that should be inadmissible. It's too weak of evidence to allow, even to put before a professional judge. Make confession, even, what about making confessions of the defendant inadmissible? They're also weak evidence. They're created normally in the black box of the, especially if no lawyer was there. Make them inadmissible. And I think, or at least require independent external corroboration. Not corroboration like judges say, well, he was consistent the whole time, or here, internal corroboration. Make it external corroboration. Make acquittals final and not subject to appeal. Less cases will be charged, less innocents will be convicted, less time will be used on trying to induce confessions, less time will be needed for judges to write their judgment reasons on very weak evidence, like you have, as I've mentioned before. In European countries, there's no limits on hearsay. All weak evidence is admissible, and then the judge is supposed to be this Hercules who can balance all of this weak evidence and still convict on it somehow, if they can write somehow convincing judgment reasons. Anyway, you can see I come from the defense. I was a former defense lawyer. You get a different view of the criminal justice system than if somebody was a former prosecutor or a former judge. So you might take this with a grain of salt, but this is my view on how you can save time and have a more just criminal justice system at the same time. Thank you very much.
Yes, and very much in line with the result of our research, as we perceive effectiveness through the purposes of criminal procedure, and we have taken an axiological approach to effectiveness. So now it will be a very short technical break. So thank you, Professor, for your insightful discussion. And now we are organizing the panel first, under the leadership of Professor Paweł Wieliński, the head of the Department of Criminal Procedure at Adam Mickiewicz University Faculty of Law. So I would like to kindly welcome all performers to the first panel to take the seat and switch the seats with our dear official guest and special guest.
Good morning. We start the first panel of the conference. Great to see so many old friends like Stephen Taman. We used to try to democratize the prosecution in Vietnam for 2 years with minor results, I would say. I hope you agree. Yeah. But we tried more than a decade ago, and I'm happy to see so many new friends here. You are very welcome at the faculty, at the university, and within the platform of this excellent project. I start with congratulations to Professor Janusz-Pohl and Professor Daniele Vicoli and all the Effective Justice Platform members. I do follow all the seminars and webinars that you have been organizing from the beginning, and I'm very impressed with the scope of topics you covered so far and those that will be presented during this conference. As the head of the Criminal Proceeding Chamber, I'm extremely happy to at least be a small part of this excellent project, and my congratulations to all of you. Search for effective instruments in criminal law is not easy. For long list of reasons, I would say. It is always contradiction of interest of participants. It's a contradiction of everything and everyone against everything and everyone in criminal trials and criminal proceedings. And this is also partially reason of problems that we have, and those that have been so interestingly presented by Professor Taman in this morning presentation. But this is also the problem of slow system and the high formalization of activities. We always have this discussion, which is the proper level of formalization of proceedings, whether we need to have more common sense, more following the legal culture, or we need more regulations. We here in Poland are now in a very special moment that we try to believe that we can get back to common sense of criminal law, understanding criminal law as an instrument of solving conflicts arising from possibility of committing a crime, and trying to find the just solution and fair trial from this conflict. Plea bargains, abbreviated procedures, and other similar instruments are models that we discussed for the last 20-30 years here in Europe, but it's been discussed for much more time in the common law legal systems. And we will focus on this part at the first panel of this conference. For me personally, it's very interesting for three perspectives that I will share with you. First is obviously as a researcher, I do spend a lot of time on the problems of conflict of interest in criminal law, and I believe that this is one of the solutions that we have to see in this perspective. But I'm also a judge of the Supreme Court of Poland, and serving as a judge, I always have a fear what would happen if there is an innocent person sentenced. Am I able to find out from the proceedings, from all these actions, from the claims that are presented in the cassation, the real essence of the law enforced there? If this was really a just verdict and the procedure was fair enough to say that it can stand. And abbreviated proceedings gives us a lot of questions in this regard. And thirdly, as a member of newly established, renewed Codification Commission of Criminal Law that is currently trying to change some directions of the criminal law that were presented for last years, we also have the abbreviated proceedings in mind when we think whether and if it is far effective, and if this brings us to what we should achieve, I mean fair trial and just solution. And all this brings us to say that effective justice, as the topic of this research and of this very conference that we are here. Effective justice, as it is this a good justice system? I mean, when we speak effective justice, do we mean a good effective system? Stephen, you spoke today about good justice system. That struck me very strongly, because I thought like this, from this perspective, if this is a good justice system, effective justice, what this means. We will try to give answers for these questions. We have 5 excellent speakers at the first panel. We have Professor Aleksander Marsawelski, we have Dr. Andrea Zampini, we have Professor Magdalena Kowalewska-Łukuć, we have Dr. Justyna Głębocka, and we have Dr. Łukasz Cora, with 5 presentations that will be presented in this order. Each speaker will have up to 15 minutes. Then we expect comments, your discussions, your questions, and then we will try to sum up and close the session according to the timeline of the conference. So, first speaker is Professor Aleksander Marsawelski from University of Zagreb. Restorative justice in Croatia, potential for an effective criminal justice system. Please let us give applause to Professor Marcin.
Thank you very much. It's such an honor to be here, and I was told I have about up to 15 minutes to give this presentation, so I will try to tell you the key aspects of my talk. But before that, I must say that it's a special honor to talk in the first panel after the inspiring keynote speech by Professor Stephen Taman, whom I actually met at a conference of our kind of mutual scholarly father, Professor Miriam Damaszka from Yale Law School, with whom actually I cooperated for many years, including in the genocide case before the International Court of Justice between Croatia and Serbia. And in that case, I was a researcher at the bottom, reading the testimonies of witnesses concerning the Ovčara massacre in Croatia, where 200 Croats were killed by Serbian forces, and Damaszka was a legal expert on the top, working with Philip Sands, who was our legal counsel in the case. And in that case shows, I think, in my view, the failure of international law in addressing the most serious forms of crime, actually the crime of all crimes, the genocide. It's a case that lasted for 15 years and didn't bring any satisfaction neither to Croats or Serbs because both lawsuits and counter lawsuits were rejected. And in this, of course, an important aspect, the most important aspect of international criminal justice are the courts, the international courts we have today, the ad hoc tribunals at that time, and the International Criminal Court today. And this is actually a point where I must say I disagree with Miriam Damaszka concerning the way the International Criminal Court is set by putting a bigger role of victims in the trial. Miriam Damaszka is often very illustrative with his explanations, analysis of criminal trials, and he often says, that a criminal trial is a dance of two, like a tango. He often says like a tango dance, and you cannot have a tango with three people. So you have the prosecutor, you have the defendant, and then if you put the victim, that creates a collision. So when we talk about effects of criminal justice, so the main effect, the desired effect, is to find the perpetrator, to convict the perpetrator, and to sentence the perpetrator. However, with the rise of restorative justice internationally, we see a greater role of the victims in criminal proceedings all over the world. And so we can say that the more and more a desired effect of the criminal justice system is also to satisfy the victim. So Damaszka was critical about that because he thinks that this is actually what is reducing the effectiveness of international criminal justice. Although, and then to a certain fact, of course, that is true because we have a very extensive proceedings in international criminal trials. However, when we talk about restorative justice, we must not only see actually the criminal trials as the focus. We need to talk about alternatives to criminal trials. The most famous ones are Truth and Reconciliation Commissions. And when we have wars like in Ukraine, and that will probably last for a while, where you have many, like thousands of victims, thousands of crimes committed, it's not very likely that you will be able to achieve justice only through criminal trials. You have to have alternatives to address the crimes, to find the truth, and to compensate the victims. And this was part, actually, of the research of, I must say, my second scholarly father, with whom I worked on a project. His name is John Braithwaite. The project he's leading at the Australian National University is called Peace Building Compared, and I was the main correspondent for former Yugoslavia, for the war in former Yugoslavia, and we wrote a paper on transitional justice cascades, where the main argument is actually to do international criminal justice, you first need to initiate restorative justice proceedings to find the truth, to go from the bottom perpetrators to tell the truth what happened, who committed lesser offenses, and then to get to the top, to the most important ones, while mostly international criminal justice unfortunately is starting from the top and not from the bottom. When you create this environment of restorative justice, it also, what is important, it creates an environment of reconciliation, while if you have international criminal trials as the focus, you have a hostility between the victim population, the population to which the perpetrator belongs, and it doesn't really heal the society. That's what we see in former Yugoslavia, and also when it comes to the International Court of Justice I mentioned, that also leads to hostility. If you have a lawsuit, you are not really willing to admit the guilt that you committed some crimes. It would be a ridiculous move in an ongoing lawsuit. So in a way, these lawsuits are actually creating problems to heal the societies. As part of this peace building compared research, we also analyzed actually, arguably, the biggest restorative justice conference in the world, in history, which took place in Kosovo, where more than 100,000 people attended an event where families were reconciling in a traditional way in Albanian customary law concerning the blood feuds. You know, in Albanian customary law, blood feuds used to be very common way of killings, common homicides. And at the beginning of the war in disintegration of former Yugoslavia, the Albanians united by reconciling first their families with blood feuds. This is this example is analyzed in this paper also as part of this project. I will not have time much to talk about definitions of restorative justice. I will just say that in some cases of mass crimes, as I mentioned, this is my first argument, is that restorative justice may be the only efficient response. For instance, in Bosnia and Herzegovina, where you had a total war between three ethnic groups, they have a backlog of cases still now, and the war ended like in 1995, and they still have a backlog of 5,000 cases of war crimes, and it's not likely they will ever finish them. The perpetrators will die, the victims will die as witnesses, so a lot of them already died. So a fast, efficient response, although of course not perfect, is maybe the only response, restorative justice. When we talk about historical development, and this is more like in criminal law theory, we have the school of positivism, the Italian school of positivism, a student of relatively infamous, famous but infamous criminologist, Cesare Lombroso, who was talking about, you know, the il uomo delinquente, or the born criminal. So one of his students was Enrico Ferri, who talked about 5 types of criminals. And out of these 5 types, only 2 or 3 out of 5 actually he advocated as a measure of reaction to crime, compensation of the victim. So only for mentally ill and passionate criminals, or born criminals, he didn't see this as a way. And so we see a restorative justice element already in this, let's say, beginnings of criminological theory. Then we had the new social defense theory led by Marc Ancel, the French criminal law scholar, who saw actually, as a reaction to crime, he sought an abolishment of the whole criminal justice system and create an alternative system that would address rehabilitate the criminal, but still this whole concept was largely focused on reaction towards the criminal, the perpetrator, and the victim was only like a side measure, so compensation that was actually directed toward the defendant. And we have a school of victimology, so which is putting in center of its interest the victim. Obviously, it's called victimology, and this is how this legal, this theoretical line of thought developed restorative justice. But there are also traditional models, and the Kosovo example is one of the customary traditions that actually are rooted in all societies to this making peace between people who are in some kind of conflict. And from the the most known example of restorative justice at its very beginning, the Kitchener experiment by probation officer Mark Yancey, we see actually how restorative justice is integrated into criminal justice. While today we usually talk about restorative justice conferences as an alternative to criminal justice system, but the main example used was actually a criminal justice response where the defendants were in the end actually fined and sentenced to 18 months of probation, but they got an opportunity to meet the victims and also to pay off the debt. So, what was inspiring, the statement of the victims, one of the victims was so delighted because she never expected to see the money, and she even decided to give it to a special purpose to help someone else. And this is the argument how restorative justice creates a cascade of positive responses. So it's when you punish someone, you're creating a negative response, but if you teach someone a lesson, if you do some good thing, actually it creates more positive responses in a society. There is an international and European legal framework. I won't talk much about it. I will only talk about, just mention the Istanbul Convention, which is sometimes misinterpreted when it comes to alternative dispute resolution or restorative justice processes, because the convention actually states that it prohibits mandatory alternative dispute resolution. Some scholars in Croatia, I noticed, say that actually prohibits alternative dispute resolutions in all family violence cases, but actually only mandatory ones are prohibited. Of course, in some situations, family violence, you cannot really put the victim and the offender together because it can create re-victimization. But we have to be flexible. It depends on the situation. The empirical research in Croatia actually shows that the practitioners are quite positive towards the mediation and conciliation practices, although it's still, when it comes to criminal justice, is a largely unknown way of resolving disputes. The comparative empirical research show that it's generally more efficient, the restorative justice is generally more efficient in reducing recidivism, and especially when it comes to juvenile crime and violent crime. Unexpectedly, most people probably believe that the restorative justice is about compensation, so it's suitable to property crime. But when it comes to property crime, it shows little or no success with regard to recidivism. However, in all crimes, as a response, restorative justice empowers the victims in numerous aspects. Realization of their right to compensation, which they typically don't get in criminal proceedings, reduction of fear, symptoms of post-traumatic stress, anger, desire for revenge, and so on. So now I will talk about how restorative justice elements can be applied in the Croatian criminal justice system. Currently, in Croatia, Croatian sentencing is very lenient. 80% of Croatian criminal sentences are actually conditional sentence, so probation. My argument is actually that restorative justice in some of these cases is very suitable. We have also borderline cases where people are convicted or actually, you know, the criminal justice response is not really suitable itself. So you have to either acquit or convict someone, for instance, who stole a loaf of bread. You know, this is the old Jean Valjean story from the Victor Hugo's Les Miserables. So you see a situation when somebody would be convicted for a crime which is very weak, very small. There could be, in some countries, argument of the de minimis. So you have a factual weakness, that the fact that it's a very low crime, but you have to decide either to convict or to acquit. And in restorative justice, you can seek other responses as well beyond criminal justice. On the other hand, you could have evidential weakness. So you have a situation between perpetrator and the victim. So alleged perpetrator hit the victim or insulted her, and the victim reported it, and or threatened, let's say, and now you have a word of the victim versus the word of the suspect, and you have to, in the end, apply the in dubio pro reo and acquit, or not even charge the suspect. So when you have an evidential weakness, a better way is maybe to put these people who are in conflict, obviously, in a restorative justice conference rather than to make a decision about criminal charge. So there are 10 examples, actually 10 ways in Croatia where you can apply restorative justice models, and I will briefly go through them. So, and I think they are applicable in many European countries, have similar models in their criminal justice systems. So the first is application of the principle of purposefulness, or the discretion not to prosecute, which is actually an exception in civil law countries. So in Croatian criminal procedure code, the state attorney may, with the consent of the victim, conditionally postpone or waive criminal prosecution if the defendant fulfills some of the obligations, of which some are of restorative nature, such as compensation, payment of damage, payment of some obligations or for charity, and so on. Second is application of the principle of purposefulness for juveniles, which is more extensive, more applied in practice. There are many obligations that could be put on juveniles, even apology to the injured party. And in the end, of course, the juvenile is not charged and one of them is also the mediation process, I must say, which we don't have for adults in this way. Plea bargaining with the defendant. In normal plea bargaining, the prosecutor is only obliged to inform the victim about it when they reach an agreement. However, when it comes to crimes against life, body, or sexual freedom, then, and in more serious cases, a consent of the victim is also required. So when you have a possibility of victim's consent, you need to, you can negotiate about things that victim could get out of this plea bargaining. Conciliation in private lawsuit criminal proceedings. So there are exceptional crimes where a victim can initiate proceedings rather than the prosecutor. And this is an ideal way. This is usually crimes of defamation as the biggest example. And in these cases, or threats, let's say, in these cases you can, the parties can essentially negotiate whether to go to a criminal trial or not. And in this process, of course, it is possible to have mediation. Also, if there are also crimes that are prosecuted only upon victim's motion, so in a way, only if the victims wants it. So the prosecutor will prosecute it only by motion. So at some point, even the victim can withdraw the motion and then discharge, stop the proceedings. And in this process, the victim, of course, can also negotiate with the perpetrator, and it was good actually that the criminal justice actors encourage this mediation process to avoid the criminal response. Conciliation with the injured party as a subsidiary claimant. So whenever the prosecutor discharges, so rejects the criminal complaint, he has to inform the victim about it, and the victim can take over in Croatian criminal proceedings, can take over as subsidiary plaintiff and prosecute the defendant, continue the prosecution. So in one of the cases, for example, that I gave, they reached an agreement that the defendant will pay 2,000 euros for a threat done through a text message, and the victim received the money, and then they discharged the case. Special probational obligations, as I mentioned, conditional sentence is an outcome of 80% of criminal convictions. So with the conditional sentence, there are a lot of special obligations that the courts can impose, and a lot of them are also of a restorative nature, and the judges can be even creative to invent special obligations that are suitable to the crime committed. We also have the adhesion proceedings, which means that we combine the civil compensation claim into the criminal proceedings, however, which undoubtedly has a restorative character. However, they are rarely adjudicated, especially when it comes in non-material damage, because this usually requires expert testimony. And restorative justice while serving a prison sentence is also possible. So if somebody is in prison, he wants to get out earlier, he can reconcile with the victim, and this will be a part of, will affect the decision on conditional release. And the last one are the other possibilities, which are informal. So before filing a criminal complaint, the victim can reconcile with the defendant even for more serious crimes. And even after serving the sentence, they can reconcile, which will not, of course, have impact on the criminal justice system, but it can affect possible civil litigation over the damage. So the conclusion is that actually, even in a, let's say, criminal, and you know, Croatian criminal legal framework is not favorable to restorative justice, you know, mediation in criminal matters. However, actually you have a lot of possibilities to integrate restorative justice in the existing criminal law framework. However, its practical application is mostly absent. And a significant number of cases are very eligible for restorative justice as an alternative to criminal justice, because we see 80% of criminal cases, people don't go to prison, they actually get a conditional sentence. So how to ensure the wider application? What I found out, actually, the main problem is in evaluation of case management and case solving cases by judges. So judges are not really motivated, nor prosecutors, to initiate mediation. They are actually, because this doesn't count as a solved case. This is usually something informally done, and it doesn't really count. So this is something that needs to be changed in order to encourage legal practitioners to do more restorative justice. Thank you for your attention.
Thank you, Professor Marcin Galiński.
sorry, but it's impressive to have 80% of restorative justice solutions in criminal trials. We hope to have 50, but we still have 20 or 30. So we should follow Croatian examples. But now we will start the second presentation given by Dr. Andrea Zampini from Sapienza University of Rome. He will speak about links between efficiency and expectations of justice in Italian system, and especially about deflation profiles of case dismissal for oblation, as we read from the shortage of the presentation. This is very interesting, this Cartabia reform, and we hope to hear some more about this, please.
Thank you, Professor Galiński. Good morning, everyone. I must steal one of the minutes I have just to say that I'm honored to share this moment with you all, and that I would like to take another moment to offer my heartfelt congratulations to the organizers and all those involved in bringing this remarkable project to fruition. And I would also like to express my sincere appreciation to the promoters of this event, Professors Janusz-Pohl and Vicoli, and also to Professor Janusz-Pohl team, which is always impeccable. Because your guidance, expertise, and support have been instrumental in shaping the trajectory of this project, and it's thanks to your leadership that we find ourselves gathered here today, and that we had this opportunity to collaborate with such esteemed scholars. Now, get straight to our topic. Professor Gabrielli and I focused our attention within this project to the potentialities of dismissal to ensure a high efficiency rate to criminal justice, and to the need to balance this goal with the effectiveness of criminal justice. I heard Professor Taman this morning fly high, and now I brutally land, but I think he will agree, at least on the merit, when I say that effectiveness must always be sized based on the goals criminal justice has, on the goals that criminal justice has been given by lawmaker and by society. And in this perspective, let's say the pursuit of the truth, let's say the fact that the accused person is convicted is only one of the goals of criminal justice. On the other hand, the main issue we must deal with, the main issue we must balance with the pursuit of the truth is the defense of individual rights, of course. And in this overall perspective, we tried to read the role of dismissal in the Italian system. Now, in this slide, in the screen, you see a little bit of data. These are the numbers of Italian criminal justice in the most recent years. You see that the blue line indicates the dismissal rate, which is quite impressive. Of course, in this part, in this number, are inserted all those lite criminis, all those facts that are object of criminal scrutiny and that are not enough, that are groundless, or we have lite criminis for which you have not the legal requisite, the legal grounds to proceed. So it's, I would say, physiological that you have such a huge number. It's also quite impressive that you see on the yellow spot are the alternative proceeding numbers, and you see that if compared with the proceedings that goes towards a trial or that goes towards decreto penale, which is another deflating instrument Italian system has, are quite low. And this is, of course, another of the fronts we must face as a system. However, coming back to dismissal, I would say that in the Italian system, dismissal has many implications for criminal efficiency, and it must be carefully projected to protect also individual rights. This morning I will address the significant role of dismissal within the Italian criminal justice system and its far-reaching implications for procedural efficiency and individual rights. Dismissal, serving as a mechanism for procedural deflation, marks the premature cessation of criminal proceeding initiated following the lodging of artitia criminis, and this results in the abandonment of the process of the trial, effectively affirming the absence of progression towards a final decision. Up to a few years ago, this kind of instrument was used only for physiological quits over proceedings. You have not the grounds to proceed in terms of evidence, in terms of legal requirements. Nowadays, this kind of instrument has been used to deflate. And when I say this, I mean that dismissal is used to define proceedings for which you could have, in the prosecutorial point of view, a chance to obtain a conviction. I will focus over on a legal institution, a legal instrument that is called oblation. It's not a new thing. It's an instrument known by our system since 1930, because the Italian Criminal Code has provided mechanisms for addressing less severe offenses without resorting to full-fledged criminal proceedings. Oblation is a term that comes from religion, as a religious mean, as a religious instrument. According to the Roman rule, it was used to get away with minor sins after paying a little amount of money, and the same concept is applied to the criminal justice system. Now I will not go into details exploring all of the phases of this instrument. I will just say that since 1930, this oblation, l'oblazione, widened a lot its application field. Because at the beginning it was used only to face minor offenses, punished only with a fine. Only contravvenzioni, we say in Italian, which can be translated more or less as misdemeanors, punished only by a fine. In the 80s, it was this instrument was used as a mean to face also contravvenzioni, which are misdemeanors, punished with a fine and with detention. So you see, this instrument started to spread. And lately, at the beginning of this century, and lately as well after the Cartagine reform, which reshaped many of the phases of our criminal trial, This instrument was used as a mean to face some specific kind of crimes, for instance, environmental crime, hygiene and work safety crime, or food crime. I mean, food crimes related to food production and selling, which is of course an important matter since we are Italians. Well, in this perspective, a new shape was given to this legal instrument, because it's for these fields, it's not anymore enough to pay a sum and get away with your contravvenzione, with your misdemeanor. Now you also have to play actively, operating some, let's say, restorative, social restorative goal, because you are asked to restore the previous situation. You are asked to eliminate the danger or the damage your crime caused. So, in these terms, this instrument has a lot of potential, because, in our opinion, it should be furtherly spread into the system. We must make it structural, and we must use it to face all minor crimes, not only misdemeanors, not only some of the crimes which are related to the fields that I evoked. At this point, since I'm speaking, I spoke roughly 10 minutes, I will let's say, gather the recommendation from Professor Galiński and save a little bit of my time for the conclusion at the end. So thank you for your attention.
Okay, thank you. I'm sure that we all are very and still even more interested in what oblation really is. And I promise I will give extra 2 minutes at the end to Dr. Zampini to give us some details about this, because we all from the continental legal system know different ways of solving this problem, but the Italian one sounds to be one of the most interesting and growing as we see. Now we will go to the third presentation by Professor Magdalena Kowalewska-Łukuć from University of Szczecin. She will give us presentation about mediation in criminal proceedings as a potentially effective tool for restorative justice. We will have some some perspectives, different European countries' perspectives. We all know that mediation still gives very little to parties in criminal law, and this sometimes is a very big problem, but probably Professor Kowalewska-Łukuć will show us the way to use mediation as effective remedy to go to restorative justice or other effective solutions in criminal law. Please, you are very welcome.
Ladies and gentlemen, dear colleagues, first of all, I would like to thank very much the project directors, Professor Barbara Janusz-Pohl and Professor Daniele Vicoli, for their kind trust and invitation to cooperate in this project. It is a wonderful experience for me and a great honor for me. I am also very pleased to appear with a paper at today's conference. I represent the University of Szczecin, but Adam Mickiewicz University is my alma mater, so it is a delight for me to stand at this hall today. In my paper, I would like to discuss the issue of mediation in the criminal proceedings as a potentially useful or potentially effective tool for restorative justice. But why do I use the phrase potentially? Because mediation is used quite marginally in Poland. Perhaps there would be nothing surprising or even nothing wrong with this, if not the fact that mediation is probably the simplest and at the same time the closest tool of restorative justice, closest to the victim and to the offender. Moreover, it can bring a number of far-reaching benefits. The results of some studies indicate that following mediation, offenders' level of compassion and empathy towards victims increase and the risk of recidivism decreases. This is what Professor Marszałkowski told us a few minutes ago. Yeah? The results of the research also remains very promising if we look for the benefits of mediation for victims. The victims of crime who use mediation compared to victims who go through, let's call it, normal criminal proceedings and who have suffered the same type of crime show a significant decrease in post-traumatic stress symptoms. They have lower scores on stress and anxiety scales, and furthermore, we can observe a significant reduction in the negative emotion expressed by those victims. Furthermore, victims report that mediation gave them a sense of emotional overcoming of the trauma, which enabled them to return to normal life. So, summarizing the benefits of mediation for victims, we can say the mediation helps them to cope with victimization in its broadest sense. Taking into account these research results, there's no doubt that mediation may bring a number of benefits, not only for the offenders, but also for the victims. So it can be concluded that mediation is a very attractive tool of restorative justice and should be used relatively often as an alternative to the standard course of criminal proceedings. In reality, however, as I mentioned before, it is not always like that. An example is an institution of mediation in Polish criminal proceedings. It is regulated in such a general and, in the same time, flexible manner that we can assume that the legislative framework should encourage its frequent application. But statistics about mediation in Poland show a rather surprising picture. Only a small number of cases goes to mediation. To be precise, it's about 1%. According to a report prepared in 2015 at the request of Minister of Justice, both judges and prosecutors are not interested in referring cases to mediation. Reasons for this may be the schematic established way of conducting proceedings, which does not assume the use of mediation. Maybe the next reason could be the lack of trust in the quality of mediation itself and the qualifications of mediators. Moreover, as the research conducted for the mentioned report shows, offenders and victims are not interested in mediation either. So, the pessimistic conclusion arises that in Polish criminal proceedings, nobody is interested in a mediation procedure, neither the parties of these proceedings nor its organs. In this case, it may be interesting to check how the mediation and the practice of its use in criminal cases looks in other countries. As a good example, contrasting with the Polish situation, seems to be the Nordic countries, where the use of mediation procedure is at a completely different level. First of all, mediation in Scandinavia has much longer tradition than in Poland. It dates back to 19th or even 18th century. At the same time, mediation in criminal cases between offender and victim, so-called victim-offender mediation, is only one of many types of mediation practiced in Nordic countries. What, then, could we learn from the Nordic countries' example about mediation in criminal proceedings? The first aspect that draws the most attention is probably the extensive training of mediators, both theoretical and practical training. The second very important aspect is the scope of impact
which mediation has on the final outcome of criminal proceedings. For example, in Finland, the mediation procedure can replace the ordinary justice system, so the prosecutor, taking into account the results of mediation, can withdraw the charges and the court can waive conviction or extraordinarily mitigate the penalty. What impact does this have on the popularity of mediation in Scandinavia? There is a very high number of cases referring to mediation. In Finland or in Norway, it's about 20%. In addition, criminal mediation in Finland, Norway or Denmark seems to be at a completely different stage of development. Also the theoretical level. I mean, reflection, the research, they are completely different, yeah? The problems which are identified in Scandinavia is the lack of full consistency between the theoretical basis of mediation and the behavior of mediators. The next problem in Scandinavia is the evaluative style of mediation. Consideration is also given how to appropriately adapt mediation to an increasingly multicultural society. At the same time, in Poland, we are instead wondering what to do to get beyond this magical limit of 1% cases referred to mediation. And one of the main problems identified with mediation is the lack of confidence in the competences of mediators and mediation itself. Yeah? So what definitely differs mediation in criminal cases in Poland and in the Nordic countries, apart from history and tradition, is certainly the different emphasis placed on the appropriate preparation of mediators. In Poland, in accordance with paragraph 4 of the regulation of Minister of Justice, a mediator can be a person who enjoys full public rights, has full capacity to perform legal acts, is at least 26 years old, had verbal and written knowledge of the Polish language, and has not been sentenced for an intentional crime or intentional fiscal crime. Moreover, such a person must have skills and knowledge in conducting mediation proceedings, conflict resolution, and establishing interpersonal relations, and must be able to guarantee the proper performance of his or her duties. The penultimate of these conditions, I mean that the candidate mediator has the skills and knowledge to conduct mediation proceedings, seems to be crucial. Fulfillment of this condition by a future mediator is unfortunately not adequately verified in Poland now. The most sensible form of this verification seems to be simply an exam. It also seems quite obvious to require from mediators to improve their qualifications, for example, by attending training courses, to keep their knowledge up to date and to develop their competences. In short, if mediation in Polish criminal proceedings is to be a useful tool of restorative justice, useful, effective tool of restorative justice, which will bring real benefits for the victim, not only economic benefits, it must be conducted by a person adequately prepared for this. Currently, this preparation remains only a certain postulate and it's not adequately verified in Poland. The need for changes in this area has also been signaled by the mediators community itself. Mediators point out that the criteria are too liberal, the verification rules are unclear, and there is no possibility of verifying persons included in the list of mediators. The second aspect worth noting is the impact of mediation on the outcome of criminal proceedings and the possible benefits that the suspect or accused person may gain from it. As I mentioned before, in Finland, for example, the outcome of mediation proceedings can have very far-reaching consequences for the scope of criminal legal response to the crime or even its implementation at all. In Poland, the court take positive results of mediation into account when determining the punishment. That's all. And maybe according to Article 60 of Polish Criminal Code, a positive result of mediation may affect extraordinary mitigation of punishment. It seems that more far-reaching or simply obligatory rather than optional effects of mediation on the reduction of the offender's sentence could contribute to greater interest in mediation and consequently to its more frequent use. Deeper research is needed, of course, in this regard. However, based on the example of Finland, a hypothesis can be proposed that such a de lege ferenda postulate would be worth to consider. So, it can be concluded that legislative changes in the influence of mediation and the sentence and in the better preparation of mediators should go hand in hand and would perhaps contribute to an increase in the number of cases referred to mediation. A greater influence of mediation on the outcome of criminal proceedings could encourage perpetrators to use it, and better preparation of mediators as a result of the research shows could encourage the organs of criminal proceedings. However, still remains the question of how to make the mediation more attractive in the perception of the victims. It seems that an appropriate design of a victim-offender mediation procedure may be the answer. I am thinking here about a special formula of victim-offender mediation, the so-called victim-sensitive mediation. This is a mediation in criminal cases which is not limited to the conclusion of settlement. The settlement is not the most important thing, but victim-sensitive mediation is primarily focused on dialogue and working through the psychological effects of the crime by both the victims and accused persons. Central to this formula is ensuring that the victim will feel safe throughout the whole process, whole proceedings of mediations. Changes that may adapt the current form of the Polish regulations to the victim-sensitive mediation are certainly not revolutionary and may even be perceived as certain nuances. They do, however, represent a certain shift of emphasis in the current formula of mediation, which does not properly focus on the needs of the victim. Okay, let's to make a conclusion because I think it's something like 15 minutes. Almost, okay. There is no guarantee that changes in the legal regulation of mediation and the practice of its use in Poland, making in the Scandinavian direction, would be fully effective. Further research is of course needed. However, there is also probably no other way to implement mediation more widely in Polish criminal proceedings than its reform. Without greater interest of the potential parties to mediation and the criminal procedure organs, we will continue to refer about 1% of cases to mediation. It seems that this interest, on the other hand, can be empowered by building greater trust towards mediators through their professional preparation. Next point is increasing the impact of mediation on the outcome of criminal proceedings, for example, by offering suspect offenders a real reduction of their criminal responsibility. And final point is adapting the mediation procedure to the expectations, needs, and specific situation of person victimized by crime. These changes will obviously not be effective overnight. It seems more realistic to forecast their effects over several years. However, the Scandinavian tradition of mediation, including victim-offender mediation, has also not been created in one day or even during 1 year. Thank you very much.
Thank you. I just commented that this was perfect 15 minutes. And now we will have, I would say, a perfect presentation, a perfect topic, and I'm sure presentation also within the frame of effective justice. I would say that this presentation is on tensions. There are always tensions between pre-trial and trial stage of proceedings, and main legal systems all around the world usually have to answer the same question. Strong pre-trial, and then as an effect reduced trial, or shortened pre-trial stage, and then real hearing. If we speak about effective justice, I understand why the organizers and the Dr. Justyna Głębocka from University of Warsaw found interesting to give us this broad perspective from different European countries how the pre-trial can influence the trial stage. So we will have a pleasure to hear the presentation on model of pre-trial proceedings and its influence on the judicial stage of criminal proceedings, comparative analysis of European legal systems. Please, here are you.
Dear professors, dear colleagues, first of all, I would like to say thank you to Professor Barbara Janusz-Pohl and also Professor Daniele Vicoli for the invitation and the possibility to participate in this project. It was a pleasure, but also a very valuable experience for the last 3 years. And thanks also for the entire team for the efficient organization of all the seminars and today's conference. I am also very glad to be here and to meet you all in person. My paper refers to different models of pre-trial proceedings and their influence on the judicial stage of the criminal proceedings. There is, of course, no time to discuss everything in details. I would like only to point out some the most important issues. A modern European criminal trial consists of 2 phases, the preparatory proceeding and the main judicial phase. And there are also several links and connections between these phases of the process. The interaction always is bilateral. The chosen model of the pre-trial proceedings influences the model of judicial proceedings. The particular shaping of jurisdictional proceedings is relevant from the point of view of the course of the pre-trial proceedings. When we think about this kind of interaction, first and foremost choices refers to the objectives of the pre-trial proceedings and consequently the process of proof. The choice of an appropriate model at this level significantly affects the scope of activities undertaken during the judicial stage. And just as to the extent to which the procedural principles such as the principle of directness, the material truth, or the adversariality and the right of defense apply. Thinking of the pre-trial model in abstracto as a kind of a hypothetical being, 2 extreme concepts can be distinguished. One of them, giving clear primacy to the judicial proceedings, reduces the preparatory stage to a subordinate stage. In its course, the collected evidence cannot be used during the main trial. It is only to serve the law enforcement authorities who, on its basis, decide on the further fate of the proceedings, and in the event of a complaint to a court on this basis carry out the functions of the prosecution. The second concept is somewhat the opposite of the first. Pre-trial proceedings are seen as the fully fledged stage of the criminal procedure, serving to collect, secure, and record evidence, not only for the purpose of the prosecution, but also for court, which may, on their basis with the restrictions of the principle of directness, issue the final decision. Of course, we can also imagine a number of solutions in between. Depending on the model chosen, the evidence collected and recorded during the preparatory proceedings may have different relevance from the point of view of the main trial and the court's decision on its merits. The first concept is close to the assertoric murder in Italy, the second in Germany and in Poland. The French model provides for a somewhat mixed form, since depending on the stage of the process, l'enquête de police or l'instruction préparatoire, the preparatory function of the pre-trial proceedings has a different weight, which translates into a different scope of the activities undertaken, their degree of formalism, and the scope of the procedural guarantees of the parties. In all the legislations indicated, the pre-trial procedure thus primarily fulfills a preparatory function, whereby evidence is disclosed to allow a decision on the future fate of the proceedings. All these systems assume, at least theoretically, that the court proceedings are the main and the most important part of the process, and the pre-trial proceedings only fulfill preparatory functions. But in practice, this can be observed the most in Italy, because in Germany and in Poland, the pre-trial proceedings play a significant role, and often evidence from this stage constitutes the basis for the final judgment. In France, the reforms of recent years shows that the importance of the pretrial proceedings and the power of the prosecutor is constantly increasing. German model is traditionally based on the assumption that the pretrial proceeding is a central part of the criminal process where the evidence gathered could form the basis of the judgment. The German pretrial procedure, being in practice the core of the proceeding, is characterized by a very strong position and role of the public prosecutor office, which decides the fate of all criminal proceedings at this stage. In some opinion, the German pretrial procedure allows for the termination of criminal proceedings in the first stage, which results in the thesis that the conduct of court proceedings is only one of many possible ways of issuing the final substantive decision of a criminal case. The aim of the German preparatory proceedings is to comprehensively clarify the case's circumstances, including the act's consequences, and record evidence for the future trial. Consequently, the public prosecutor's office has a full range of investigative activities at its disposal. Such a system de facto leads to duplication of evidentiary actions and the reading out of evidence from the preparatory phase at the trial. Evidence taken during preparatory proceedings is often crucial for the final decision. Similar model solutions can be observed in the Polish legal system. The main objective of pretrial proceedings is to clarify the circumstances of the case and to collect, secure, and to extend necessary record evidence for the court. These objectives are the same regardless of the form in which the pretrial proceedings are conducted, śledztwo or dochodzenie. Moreover, the investigating authorities, as in Germany, have at their disposal all the evidentiary possibilities, apart from those expressly prohibited by law. Thus, the evidentiary options during the preparatory stage are the same as at the court stage. And at the same time, it has been decided that the value of these evidences are equal. The possibility of conducting a limited investigation, so-called dochodzenie ograniczone, which allows for a clear reduction of evidentiary action, in practice is not widely used. Such a state of affairs leads to an evident elevation of the rank of preparatory proceedings at the expense of the stage of court proceedings, which takes on a secondary character and comes down primarily to the control of the evidentiary acts already performed during the preparatory stage, and the duplication of evidence, often with a restriction of the principle of the directness and adversarialism. When comparing the German and Polish solution, it should be noted that the German pretrial model, that in German, there is a judicial authority in the form of the pretrial judge who uploads the legality of an investigative activities and fundamental guaranteed right. In Poland, there is no such a body. The judgment control of the investigation can be acted only by the court appointed ad hoc for each activity. The French model assumes a clear distinction between two forms in which it can be conducted. Among other things, the differences relates to the impact of the phase of this phase on the stage of the judicial proceedings. To put it very simple, a judicial investigation, instruction préparatoire, conducted at least under the supervision of an investigating judge, is a complete procedure aimed at establishing the truth and collecting evidence for the purpose of the main trial, while a police investigation, l'enquête de police, is a quite quick and informal procedure, the main purpose of which is to decide on the further course of the proceedings. The difference between these two forms is noticeable in the scope of the evidentiary possibilities. In a l'enquête de police, only a part of evidentiary acts can be done, and they are often not the evidence in the strict sense. And also in the warranty rights of the parties, they are more broadly guaranteed in a judicial investigation, which is often adversarial. However, in practice, The evidence gathered in the framework of the l'enquête de police permits the judicial proceedings and forms the basis of the judicial decision in a very similar way like during the judgment investigation. Moreover, the reforms of recent years indicate a trend toward the expansion of the powers of law enforcement authorities in the field of the evidentiary proceedings, clearly extending their possibilities. And also not without significance is that the prosecutor has vast powers in terms of consensual forms of termination of proceedings, which, against the background of the opportunism prevailing in France, are a manifestation of the prosecution increasingly strong power and the transfer a part of the adjudicatory competence strictly to him. Taken together, the reform trends of recent years in France are moving towards a real strengthening of the role of the pre-trial procedure. The legislation that most limits the importance and scope of activities undertaken during pre-trial proceedings is Italy. Italian criminal process combines features traditional to the continental system, but also the common law systems, and the procedure has been shaped in such a way as to explicitly give primacy to the judicial procedure, reducing the pre-trial proceedings to a subservient role. Thus, the focal point of Italian criminal is now the main trial, where evidence is gathered and evaluated, respecting the principle of equality of parties. In contrast, the pre-trial proceedings are primarily intended to acquire sources of evidence, which will only become evidence when they are conducted directly at trial. Thinking about different models of pre-trial proceedings, all the advantages and disadvantages of different solutions should be taken into account. The reason for reducing this phase of the process is primarily the importance of the court proceedings and its superior position, which should be quite obvious. It is only the main hearing that procedural rights can be fully guaranteed, allowing the active participation of the parties in the trial and exercising a real influence on the course of the evidence, which translates into the realization of procedural guarantees and thus the creation of conditions contrary to inquisitorial solutions, but also into greater opportunities to reach the material truth. But we have to remember that giving the primacy to the main trial, however, should consequently lead to reduce of the preparatory proceeding. On the other hand, looking at the model's impact on the efficiency of the trial and the principle of material truth, one must recognize purely pragmatic issues related to the evidentiary possibilities. By carrying out actions within a short moment of disclosing a crime, law enforcement authorities have a greater chance to get to the truth. They also had a better experience, better personnel, as well as technical facilities, allowing for a high application of the state-of-the-art forensic techniques. This positively contribute to implementing the principle of material truth. Furthermore, a broadly conducted evidentiary procedure in the preliminary phase of the trial will favor the implementation of the principle of concentration of evidence, and as a result promote the speed and effectiveness of the adjudication of the case before the court. However, the inquisitorial nature of the preparatory proceedings remains a critical drawback, significantly limiting the guarantee rights of the parties, above all the suspect, who often has no real opportunity to participate in the evidence process. The lack of active participation of the parties may negatively affect the principle of material truth. At the same time, it is a regularity to be noted that the more strongly the preparatory function of the pre-trial proceeding is emphasized, the greater the influence of the evidence gathered in the preliminary phase of the trial, rather than at the main trial on the final decision on the criminal liability. The practice draws attention to the unfavorable effect of such solution of reducing the court proceedings to a purely subordinate role, consisting only of controlling the activities of the pre-trial proceedings and duplicating them at the main trial, which negatively affects the length of the entire proceeding and the time to wait for appropriate criminal response. Above all, however, repeating the same evidence runs the risk of degrading its quality and violating the guarantee rights of the parties. A witness who is questioned repeatedly already knows the subject matter of the proceeding, may verify their knowledge with other sources of evidence, and may, under the influence of time, fail to remember many relevant circumstances. In practice, in the indicated models, this leads to frequent recourse during the trial before the court to the preparatory material and based on files that are collected during the pre-trial stage. There are many dilemmas in choosing the appropriate pre-trial model. Recognizing the threats resulting from increasing the role of the preparatory proceeding, two directions in shaping the model of criminal proceeding can be distinguished. On the one hand, the legislator may move towards reducing the role of preparatory proceeding by reducing the role of evidence from this stage of the process and increasing the adversarial nature of the judicial stage of the proceeding, and Italy is an example. On the other hand, increasing the protection of warranty rights may occur by increasing the adversarial nature of the pretrial procedure and the participation of the judicial factor at this stage. However, what should be noted that the last decades of the development of the continental criminal process clearly show a trend toward the introduction and expansion of plea bargaining, which entails making a final decision on criminal liability solely based on the evidence gathered during the pretrial phase without holding a trial. The growth of consensual but also opportunistic solutions is clearly moving European legislation towards extending judicial or quasi-judicial powers to the prosecutor's office. Consequently, this leads to a growing role for pretrial proceedings, which increasingly constitutes the only stage of criminal proceedings, with the final decision based on evidence carried out on an inquisitorial setting before the prosecuting authorities. More and more often, it is the prosecuting authority at the preparatory stage that finally decides on the outcome of the entire case, not only by discontinuing the proceeding, but also by applying a specific criminal response. It can be considered that this leads to a devaluation of jurisdictional proceedings and judicial settlement of criminal cases. And for the conclusions, I will think after all, yes, Professor, as you can. Okay, so all the conclusions, I think, at the end of the panel. Thank you very much.
We need to have something for you at the end. So we will have these conclusions and difficult questions, which I can promise you will receive. And now I have to give you best regards from the next speaker that was supposed to join us, Rodrigo da Silva Brandalais. However, he cannot join us in person because of the huge flood in Brazil and the cancellation of his flight. So he asked us to give you his best regards, and he will join us online later. Later on during the conference. This way, we will go through the program to the presentation that will be delivered by Dr. Łukasz Cora from University of Gdańsk on, I would say, another fascinating topic. We share this fascination, which is the abuse of procedural rights, abuse of law in this perspective of procedural actions. Abuse of procedure is something like actions in shadow. We normally see something different that we should see when the law is abused. And this presentation will be focused on abuse of law and admissibility of evidence. The topic is abuse of evidentiary actions in pretrial proceedings towards procedural sanctions.
All right, so as an introductory, I just want to say and express my gratitude to Professor, of course, Janusz-Pohl and Professor Vicoli for this great conference and the great effective justice program. And I think I want to be a buzzer beater in addition to NBA and NHL, because we are all tired and we are all waiting for the coffee break, right? Let's assume that I have 12, maybe 15 minutes, at least 10, 20 minutes, and straight to the point. The biggest problem and the inheritance of Polish criminal procedure is, of course, the concept of pre-trial proceeding. I mean, we all know here, sitting and hearing that the pre-trial proceedings is a massive problem, and it's going to be a massive challenge for the Commission to set up new regulations, new norms that should change the thing. Of course, the performance of the law enforcement function cannot imply complete freedom of action on the part of law enforcement authorities and the unfettered choice of methods and means, especially in the pre-trial preparatory proceedings. In my humble opinion, it can only take place on basis and within the limits set by the law. Therefore, in order to protect fundamental human rights and freedoms, procedural establish rules prohibiting the taking of evidence under certain conditions and creating restriction on its search and introduction and of course taking of evidence. First of all, it should be pointed out that the use of notion of abused evidentiary actions and evidence law in criminal trial is just a theoretical concept covering situation in which going beyond the permissible frameworks or limits of procedural powers nullifies the ratio legis of functions of a given institution. It is difficult to underestimate the practical consequences of finding in this regard. One fundamental issue is, in my humble opinion, worth noting at this point. It concerns the impact of the legal nature of the abuse of rights in criminal trial in its broader sense, on the resolution of specific interpretive issues related to the application of procedural and substantive criminal law, and thus securing the implementation of statutory, constitutional, and conventional standards and guarantees arising from the applicable criminal law legislation. Of course, two specific issues should be first pointed out. First, what is actually to be understood by a fair evidentiary proceeding? What are the essential elements and whether it constitutes an indispensable substrate of a fair criminal trial? Especially when in Polish conditions, unfortunately, the criminal procedure undertaken by CCP rules provisions are being displaced by undercover police investigations. And this is one of the crucial challenges for codification committee. And second of all, what kind of abuses of the evidence procedure and evidence actions imply as a consequences that criminal proceedings may not be considered as fair. Actually, the fairness of the evidence finding imposes certain requirements. The thresholds of fairness, on the one hand in abstraction, in relation to each and every case where the minimum conditions is the evidentiary proceedings are shaped in such way that the criminal trial is fair, and on the other hand that in concreto these proceedings can be considered as fair is a case under examination by pre-trial authorities. So we have to focus on particular consideration of the principle of necessity, proportionality, and other aspects of correctness of evidentiary actions. That's why we can divide two essential approaches. First of all, we can consider that the analysis from the perspective of conventional or constitutional rights, such as Article 2, right to the protection of life, right to the freedom from torture and human and degrading treatment, right to the privacy and freedom of expression, are the most influential as they actualize the obligation on the part of the state to proceed and clarify the allegation of their violation. In this sense, it's therefore a directive to conduct proceedings diligently and fairly. And secondly, it should be pointed out for the fairness of the evidentiary proceedings, the most important thing is what procedural values and principles have been abused, in particular the principle of the right to defense, including the right to be assisted by, especially in the early stage of criminal proceedings, the right of access to evidence, the principle of equality of arms, the right to proper information, the privilege against self-discrimination, and the right to silence. In addition, it should be noted that the elements influencing in the unreliability of the evidentiary proceedings are coercion, deception, and criminal threats in terms of coercing evidentiary statements from the person being prosecuted. And what I want to say is something about classification and types of abuse of evidentiary actions. Of course, from the point of view of defining the criteria of the gradation or prioritization of the abuse of evidentiary actions and evidentiary law, we have to take under consideration elements such as the rank of civil liberties, both constitutional and conventional, the nature and character of evidentiary actions, its effect on the course and outcome of the proceedings, the importance of the power, the degree of its abuse. The following types of abuse of the law of evidence in criminal trial can be distinguished into three groups: misuse of vulnerable evidence activities, the abuse of the law enforcement functions, and the instrumentalization of powers in evidentiary actions, and furthermore behavior which are not evidentiary acts, which has an impact on the course of evidence, but we're going to skip that. The abuse of vulnerably evidentiary actions, we may also skip this issue. Let's move to the legal consequences of abuse of evidentiary actions. Well, the assessment of the abuse right of evidence from the point of view of the impact of the procedural consequences by going beyond the scope of statutory right and the purpose of given evidentiary act is not an easy task for two fundamental reasons. Firstly, due to the fact that the institution of abuse law is not known, has not been adopted in the Polish CCP. Secondly, due to the fact that the criteria presented above for the classification of abusive actions should be treated differently from the point of view of their impact on the course of evidentiary proceedings. So the fundamental questions on this case, on this issue, which needs to be formulated at this point is how this, in terms of their nature, minor breaches of the law of evidence, should be sanctioned, so that the material conducted and obtained of the basis of the abuse of an act evidence is not qualified as the evidentiary basis for the ruling authorities. In other words, how should the legal consequences of an abuse of the right to breach and an abuse evidentiary action be resolved for the sake of fairness in the taking of evidence? It must be determined whether and in what respects the prosecuting authorities committed misconduct. So how the discretion is exercised depends on the specific circumstances of each case, including 4 factors. Factors such as seriousness of violation of accused rights, whether the police acted in bad faith or maliciously, whether the abuse was committed in urgent or necessary circumstances, the possibility of sanctions being imposed on the persons responsible for the offense, and the seriousness of offense with which the accused is, or suspect person accused is being charged. The relationship between, of course, ex officio allegations and abuse of process. A case may be considered an abuse of process if the person held responsible would not have been afforded a fair trial, and or the trial would have been unfair to the suspect. And certainly from the point of view of consequences for inappropriateness of the choice and conduct of specific evidentiary acts, the assessment of their impact on the taking of procedural decision must actually take into account the indicated criteria for the gradation of the abuse of evidentiary actions, and this failures both at the preliminary stage of proceedings, during the pretrial proceedings, and even at the trial stage, although related to legal actions, however, beyond the scope of the authority and purpose of a given evidentiary actions, require the, in my humble opinion, systematization of legal consequences, which by their very nature cannot be equivalent to those sanctions to be applied to nullity of the law of evidence. And in terms of legal consequences and legal assessment of such an action, it should be considered as ineffective. This should mean suspension of the evidentiary proceedings. So the British called it stay of proceedings until the performance of an evidentiary action which, by interfering with the right of privacy, meets the normatively determined purpose of its necessary, adequate and proportional in the circumstances of the given case to the gravity of the crime and the risk related to influence of the infringement on the further sequence of evidentiary steps. In particular consequences, and that's going to be one of my last words about it, the sanctions of ineffectiveness combined with the suspension of evidentiary proceedings is an expression of possibility of removing these failures in relation to sensitive, vulnerable actions only in a manner which presupposes the removal of these failures and functional objective nature as a result of divert and renew action originally carried out by the parties. And if you look at the division of the model, if you look at the Herbert Packer, and if you look at the Miriam Damaszka model, we have to confirm that unfortunately Poland transformed its proceeding model into illiberal. First of all, it's a crime control model undertaken by the state, by its authorities, with the huge impact of the trial proceeding. And second of all, the state is very active. It's very proactive, right? So in this situation, in my humble opinion, because I know that I haven't got enough time to conclude a matter of nullity, which I hope I'm gonna have time to discuss, of evidentiary action. We must adopt this institution, abuse of law, and especially abuse of evidentiary acts, if the police inquiry, which is actually undertaken undercover by not the CCP standard but the police standards, displays the rightful criminal proceedings. So I hope that I beat the buzzard, and I do hope that it's just an introduction for the discussion, and I do believe that I stress some major problems, and it will just give a good approach for the later, I think, discussion for the whole panel. Thank you very much.
Of course, we do share all these hopes and conclusions, and this leads us to the final part of this panel, which is the discussion part. So we are very welcome for comments or questions. We try to settle the microphone's functions, but if they will not work, you are invited to take the floor and ask questions or comment from this microphone here. Is this working?
Professor, you're more of an expert in this.
Of course.
So if you could.
Maybe if I am an expert, maybe on this, on computer microphones.
Perhaps I have to.
Usually it works when you don't need that. So maybe there is someone who wants to take the floor. Okay, please introduce yourself. You can speak either from there or you can use the microphone.
Thank you very much. I hope that I'm hearable from this place. Thank you very much for the interesting topics and presentation. It was really a pleasure to hear all of you. And I have one question, only one question to Professor Marcin. Sorry, please apologize me. My name is Piotr Karlik, I'm the Criminal Proceedings Chamber.
If I can stop you for a second, Doctor, please use the mic.
Thank you very much. More than welcome. Thank you very much once again. So everybody can hear my pleasant voice. Okay, so I have a question for you because one of the resolution you said and mentioned it was conditionally postponing the criminal proceedings to implement the restorative justice system. And I would like to ask you, what are the outcomes of this conditionally postponing the criminal proceedings? What can happen after, if we can quit the proceedings, or the perpetrator and the victim can decide that we would like to stop the criminal proceeding and we are not interested anymore in criminal proceedings at all. So what are the possible outcomes? Thank you very much, and once again, thank you very much.
Do you hear me? Okay. Yes, thank you for your question. Conditional postponing of criminal proceedings is regulated only in the Juvenile Justice Act. So only when we have minors, the prosecutor can decide to postpone the whole criminal proceedings under the condition that the minor can apologize or compensate, provide compensation to the victim, or enter a mediation process. So if it fails, the minor does not fulfill the obligations imposed, then the prosecutor will indict him. So it will go into a regular, proceedings. It's not regular, it's minors, proceedings for minors, which is dealt by specialized courts for juveniles, but it goes to the criminal proceedings.
Thank you. Next question, please. Don't be shy, we have time. There will be lunch, even if you will ask questions, no problem.
Hello, Michał Wawrzyńczak, Department of Legal Theory and Philosophy at Adam Mickiewicz University. So I have a question for Professor Massalski as well. You started with transitional justice context and talked about restorative justice there. And one of the lessons that the transitional justice field has learned is that those non-traditional methods of imposing justice in that context can also feel oppressive for the victims. Because in this grand reconciliation processes that are often supported by the NGOs, like International Center for Transitional Justice, this goal of achieving reconciliation often forces the victims to take part in those proceedings. They feel obliged to for the sake of the community. And the result sometimes is that neither the victims feel that their voices have been listened to, and also that there is no true reconciliation for the perpetrators, because after the whole procedure is finished, they face some informal sanctions like ostracism, name calling, sometimes even acts of violence. So, is there a way to avoid that? And are there any lessons for ordinary criminal proceedings that we can learn from that? Thank you.
Thank you. That's a very interesting and also complex question. The way a restorative justice should be applied, it should be flexible. So it shouldn't be automatically mandatory involvement of victims. So it should be actually based on individual victims' assessment beforehand. So to be able to assess whether the victim is actually suitable for restorative justice, and actually the victim should consent to it. So it shouldn't be, you cannot have a successful mediation process if the victim is obliged to, go into this, because such process is not honest. In the end, it will probably fail. First of all, it has to be flexible. It has to be consensual. So any kind of mediation, in that sense. But I also, as I said, I think there's also importance to integrate these restorative justice elements more broadly. So also, I support the way it's also implemented in the Rome Statute of the International Criminal Court. I mean, more of a problem is actually that we cannot rely only on that court and on domestic courts. I think we need also internationalized courts, like these hybrid courts, in between. So the proper way to integrate restorative justice model in the international criminal justice system is to, as I said, to start with restorative justice at the bottom, and then to catch the bigger fish, like in the middle, who are actually responsible, who ordered the crimes to be committed, the foot soldiers and people on the field. So because often the middle ranking military is actually the most responsible, but also in other cases also the people at the top. And ICC should be reserved for the people at the top, like the generals, the presidents, and so on, while there should be a hybrid response in between. So, and she should be local, and that's how we would ensure a local impact and integrate also, of course, victims' voices in all these proceedings. Although, I mean, as Damashka would say, it is a bit burdensome for the trial, but we need the victims and we need to address their needs, as this is a proper way to deal with the whole problem, the conflict that appeared. Yes, so that's, the conclusion, as I said, we have to be flexible. It's not like one size fits all solution.
Thank you. Okay, we have last two questions.
About that one, a follow-up, do you have an article about that one?
Yeah. Wait a second. We will give you a microphone.
So the title of you asked me about the article, so it was on my slides, Transitional Justice Cascades is the title of the article. Yeah, Transitional Justice Cascades. Thank you.
Marcin Galiński, the Jacob of Paradise University in Gorzów Wielkopolski and Institute of Justice. At first, I would like to thank of our performers for very interesting speeches. To be frank, I can have a question for each performer separately, of course, but we have only 10 minutes. So I have a question to the Professor Kowalewska-Łukuć. As you mentioned, mediation in criminal process is not popular, on the contrary to civil process, when they are beginning more and more popular, and there are provisions which serving to making mediation or other consensual methods prefers. So I have question, perhaps what kind of provision could be or should be implemented to make mediation more popular, and should be any limitation to kind of criminal acts, because it's very difficult to imagine that in case of, for instance, crime of persistent harassment, that mediation could in every case be effective. Thank you.
Thank you very much for this question. But frankly speaking, I don't have a clear answer. I think that nobody in Poland today has the clear answer for this question. But as I told during my speech, I think that we have to try to somehow formulate the mediation in Polish criminal proceedings in the direction to give it the greater impact, to make more with reduction of penalty. I mean, now the offenders are not interested in mediation because they gain little from it. If we give them more, they will be more interested. If they will be more interested, the mediation will be much higher rate than it is now. The second part of the question was about, I don't remember, sorry.
The second part of my question is about limitation in the case of implementation provisions which order parties to mediate. And the question is about the limitation. However, if you notice that that issue should be
what type of cases, yes, should go to mediation?
No, to types of criminal acts.
Okay, what types, yeah?
Yes, types.
Okay, so I think it's quite obvious for us that not every case is suitable to be referred to mediation. It's obvious, yeah? I think the first and maybe the most important condition is the agreement of both parties. I mean, the offender and the victim. They have to agree, yes, for the mediation. Next, I think it's very important that the offender admits his guilt, his or her guilt. Without it, the mediation could be very hard. Yeah, but I will not point the specific type of crimes which shouldn't go to mediation. Maybe not usually in Poland, but in other countries we see the cases with rape, with murder, when the case go to mediation. Yeah, with murder it's of course without a victim. Yeah, but it's possible. So I will not point to the specific cases that are unsuitable to mediation at all. Yeah.
Thank you very much.
If I can
yes,
I mentioned also, like the case, Kosovo case I mentioned was about homicide. So you can have even restorative justice because of blood feuds, right? You can have restorative justice also in homicides. And maybe to also answer to your question, an example about the restorative justice inside the when we talk about war crimes. So there was a case in our research in Bosnia where a woman was raped, as you mentioned, rape, so that's why I remembered it, in war. So it's a war crime, rape is a war crime. And after many years, they found the perpetrator in Switzerland, and he was arrested and extradited to Bosnia. And the victim actually, what the victim wanted, I mean, she wanted to repair her roof of her house. She had a bad roof, so she didn't have a place to live properly. And she agreed in these proceedings he pleaded guilty to pay the compensation. I don't remember the exact amount. It was quite a high amount. And also, at that time, Bosnia, and I think they still have this law, if you get a sentence up to 2 years of imprisonment, you can replace this sentence for a fine. So you pay a fine, so it's converted, your prison sentence, to a fine.
So in the end, he ended up paying a very big fine and, let's say, a big compensation. And he was working in Switzerland, so he could pay this money, which is a bit untypical because most war criminals who are doing bad things on the field will not have that money to pay war crimes compensation. But in that case, that was possible. And the case was also present in the media, and the media were very critical because one journalist said that by paying this money, the perpetrator treated the victim as a prostitute, paid for rape he committed before. But actually, when we did interviews with the prosecutor, he said actually that's what the victim really wanted. She didn't care whether the perpetrator would go to prison. All she wanted to is to repair her roof of the house. So you can see there's no one-size solution to this. It's very complex problem, but I think in any case it is very important to attempt to try to do a restorative justice if it is possible. Of course, in some terrible crimes it's not possible, but even in some that are like this, individual crimes, it is.
So we see that there can be different answers for what effective justice is. Unfortunately, we have to close this session because the lunch is waiting, but before, I want to remind you that we spoke about the system of restorative justice, about oblation, about mediation, about pre-trial as a stage of proceedings, and about the abuse in evidentiary acts. Before I close this session, I will give a floor to Dr. Zampini.
Professor, if I can ask for permission for Professor Domenko to take the floor, because she also asked for permission to speak. So,
yeah, I saw that.
If you will allow.
Okay. No, it's okay. It's conditional.
No, I was not allowed to have a chance to leave this after the 1:30, so we will give the floor to Dr. Zampini now, because you see, he was the one who spoke the shortest, and we promised to give him a chance to close his presentation and answer this question that I promised you. How your research can give us answers and lead us to effective justice.
Okay, I will try to do all of this. I know I'm ashamed for my country and my culture because I strictly observe the rules of engagement, but I did it to preserve the friendship with Professor Galiński, so I hope this was effective in these terms. However, trying to recollect, in our legal system we have three kinds nowadays of oblation. The traditional one, which is only for misdemeanors punished only with a fine. Another one, which was extended to misdemeanors punished with a fine and with detention. And another one that was used at the beginning for answer to environmental crime and work safety rules crimes. The Cartabia reform intended, with the delegation law, to extend the application of this instrument, indefinitely extend, in the sense that the parliament gave the government the power to broaden this instrument without particular limitations. The government, it was a particular moment, indeed the government fell right after, had not courage enough to go this far and chose to limit the extension of the last one of these kinds of oblations, which is the one that the one in which you pay a sum of money and you are at the same time forced to remove the damages or the dangerous consequences of your crime. It extended this kind of procedure to food selling and producing crimes. which is important, of course, but it's a water drop in the ocean, which is it's not really useful in terms of efficiency. But let's say we can achieve one day the goal to to really extend boundaries of oblation, to really extend this goal to of hybridization with restorative, social restorative models. For instance, we can do it by extending the application of the instrument to major crimes. I mean, the lower sphere of offenses. Okay, maybe this could help effectiveness, and I tell you why. But we must also consider a link. We must also consider another interaction between this instrument and the statute of limitations. And this is a reasoning that is true for oblation as well as for the other abbreviated procedure in Italy and abroad, I would say. Because when you are accused of a minor crime, if this purpose will become reality one day, I mean the extension of the oblation procedure, you will have three options in the end. You can choose to oblate or oblationate, I don't know how to translate it, and pay a sum, restore the previous situation, and end your experience in criminal system. And this is a solution which balances quite well the tension between efficacy and efficiency, because the crime obtains an answer by the state, by the legal system, and the procedure ends really soon. On the other way, you can choose to go with the ordinary options, with the ordinary proceeding, because maybe you claim that you are innocent, and maybe you are. And at this point, you have the right to go forward, and at this point, we balance effectiveness and efficiency in the sense that effectiveness is protected, because we must give the accused person the chance to prove his innocence. This is a goal we pursue, and this is a goal through which we can reach effectiveness, even if it's not really granted in terms of efficiency. But in Italy, especially in this moment, we have a third option. The accused has a third option, which is start counting and say if it's better just to wait because of the statute of limitation expires. And this is an option which really is lacking on both sides, effectiveness and efficiency. Also, maybe we could, our lawmaker did it somehow, I have no time to explain why. Maybe we can read this this expire of the terms of the statute of limitation as a terms of efficacy, because we end this experience, we close the file. But also, if we read this phenomenon in this perspective, it's not really respondent, it's not really in line with, I think, our values, because yes, we followed the procedure strictly, we obtained this result, but why? I will close with a joke, with a medical joke, where the surgeon explains to the parents of the sick person that the surgery was perfect. Nothing went wrong. All the procedures were followed perfectly, but the patient died. This is. I hope I answered also Professor Galiński question. Thank you.
Thank you very much. Effective
justice and the patient had died. So the panel is complete, I believe, with this final joke. Thank you for all these excellent presentations to our speakers. Thank you to all audience of this panel of the conference.
Okay, thank you very much. Ladies and gentlemen, as it was presented just in a few seconds before, my name is Wojciech Filikowski. I am Associate Professor at the Faculty of Law, University of Białystok, the Chair of Criminal Law and Criminology. I'm extremely pleased to welcome the speakers and the audience to our remote second panel entitled Special Abbreviated Procedures and Evidence Part 2 and Organization of Judicial System Part 1. I would like to thank the organizers for entrusting me to serve as a moderator during this panel. With great honor also comes great responsibilities. The mine is to keep an eye on the length of our panelists' speeches. Therefore, the speeches should last about 20 minutes, which I take the liberty of reminding the speakers of. However, there is a spare time to ask some questions and answers afterwards. Therefore, without further ado, and counting on the grace of telecommunication connections, we will begin with the first speaker, Professor Chiara Gabrieli, University of Urbino. She's going to present a paper entitled Between Efficiency Urges and Expectations of Justice in the Italian System, Deflation Profiles of Case Dismissal for Particular Tenuity of the Criminal Act. Please, our virtual floor is yours, Professor.
Thanks. Good afternoon to everyone. First and foremost, I would like to extend my heartfelt gratitude for the invitation to speak at this event. It is truly an honor to be part of such an esteemed gathering, and I'm deeply appreciative of the opportunity to contribute to this meaningful project. I must also take a moment to extend my warmest congratulations to all those involved in organization and executing these remarkable initiatives. Especially to the energetic Prof. Barbara Janusz-Pohl. Your dedication, hard work, and vision have undoubtedly played a pivotal role in bringing this project to fruition. Thanks a lot. I also must offer my apologies for not being able to join you all in person today. Due to unforeseen duties at my university, I find myself unable to be physically present. Nevertheless, please know that my thoughts are with you all, and I'm fully committed to participating in any way possible to ensure the success of this event. Today, I will present a focus about the crucial role of dismissal in the Italian criminal justice system and its implication for procedural efficiency and individual rights. This morning, Dr. Zampini, with whom I worked to the chapter of our book, focused on the potential of oblation, while I am about to analyze the new tool of particular tenuity of the offense. Dismissal is a tool for procedural deflation, brings about the premature halt of criminal proceedings initiated after lodging a notitia criminis. This entails the abandonment of bringing the accused to trial, effectively validating the lack of a transition to a final decision. However, the decision to dismiss must adhere not only to constitutional mandates, but also to principle of fairness and equity. Article 112 of the Italian Constitution mandates criminal prosecution, albeit with exceptions where certain circumstances, conditions outlined in the Criminal Procedure Code are not met. Dismissal, therefore, serves as a mechanism to determine whether the prerequisites for prosecution are absent, albeit in exceptional circumstances. To ensure impartiality and accountability, the decision not to prosecute must be subject to judicial control. In the Italian system, the judge for preliminary investigation plays a crucial role in overseeing prosecutorial decisions and reacting to any evasive behavior. This oversight ensures that unintentional mistakes are avoided and that the accused person's rights are protected, regardless of their personal connection, political beliefs, or social and economic status. Nevertheless, Italian justice system has faced chronic challenges, leading to proceedings dragging on beyond reasonable timeframes and often resulting in the expiration of the statute of limitations. Legislative policies and resource constraints have exacerbated these issues, with defendants sometimes opting to wait for the statute of limitation rather than seeking abbreviated procedures. While this behavior can meet efficiency goals, it completely misses the effectiveness of justice, since it results in a radical abandonment of the scrutiny over crime. Moreover, in the recent years, there has been an overbounce of criminalization policies, burdening the system with minor offenses that could be more effectively addressed through non-criminal sanction. Consequently, there has been a shift toward utilizing dismissal to redirect resources towards more serious criminal offenses, ensuring that limited resources of the justice system are allocated where they are most needed. Recent reforms have reshaped the criteria for dismissal, emphasizing the need for solid evidence before proceeding with charges. This includes considering whether the offense is particularly heinous and whether the behavior is habitual. By raising the threshold for prosecution, these recent reforms aim to ensure that only cases with a reasonable chance of conviction proceed to trial, thereby reducing the burden on the justice system. Dismissal based on particular tenuity procedure represents a form of diversion from traditional trial proceedings. It recognizes the inadequacy of a criminal trial as a response to certain cases, whether due to the mild nature of the offense or the inability to restore the lawful status quo. However, it's essential to recognize that opting for particular tenuity dismissal may result in less favorable treatment for the accused, both in terms of premises and consequences. It implies a crypto conviction based on evidence gathered during the investigation, and it must be entered into the criminal record, albeit with limited legal force. In conclusion, while dismissal serves as a valuable tool for procedural efficiency and deflection, its application must be balanced with consideration of fairness, individual rights, and the overarching goals of the criminal justice system. By carefully navigating these complexities, we can ensure a system that upholds the rule of law while promoting accountability, rehabilitation, and the protection of individual liberties. Article 131 bis of the Criminal Code serves as our guiding light through the legal regulation of particular tenuity. illuminating the path towards understanding the nuanced interplay between legal principle and societal values. At the heart of our discussion lies the essence of what constitutes a heinous offense. This multi-phased concept is defined by two pivotal factors. The harm inflicted on the protected legal asset and the non-recurring nature of the offense. It is within this framework that we navigate the complexities of criminal liability and the implication thereof. The recent Cartabia reform, named after the former Minister of Justice, represent a seismic shift in our approach to addressing heinous offenses. By expanding the applicability of Article 131 bis, this reform has broadened the scope of offenses eligible for consideration under this clause. No longer confined to offenses punishable by a maximum of 5 years imprisonment. Our legal landscape now encompasses offenses punished with a minimum imprisonment of 2 years. This important recalibration, driven by the imperative of rationality and proportionality, underscores our commitment to upholding the rule of law while adapting to the evolving needs of society. Furthermore, the determination of penalty limit necessitates a meticulous examination of the circumstances surrounding the offense. Factors such as the nature, method, object, time, and place of the offense play a crucial role in assessing the severity of harm inflicted. It is through this holistic, evaluation that we endeavor to strike a delicate balance, ensuring that justice is served without undue harshness. In our quest for fairness and equity, we must also confront the issue of habitual behavior and its implication for the tenuity of an offense. Article 131 bis casts a discerning eye on the past actions of the accused, seeking to discern patterns of behavior that might undermine the notion of non-punishability. By scrutinizing the individual history of delinquency, we aim to identify recurring patterns of misconduct that warrant closer scrutiny and perhaps a departure from leniency. However, as we navigate the intricate web of legal precedents and legislative reforms, we must remain mindful of the broader societal implication of our decisions. The pursuit of justice is not a solitary endeavor, but rather a collective responsibility that requires us to consider the different needs and perspectives of our community. In doing so, we can forge a path towards a more just and equitable society, where the principle of fairness and compassion guide our every action. As we continue our exploration of dismissal and its implication, let us remain steadfast in our commitment to upholding the fundamental principle of justice and equity Through dialogue, collaboration, and a steadfast dedication to the pursuit of truth, we can chart a course towards a brighter future for all. In the end, we find ourselves confronted with a groundbreaking development, the unprecedented dismissal itinerary crafted by Legislative Decree number 28 of 2015. This specialized procedural pathway, designed to optimize the potential deflection of particular tenuity in dismissal proceedings, represents a bold step toward ensuring fairness and efficiency, both of them, in our criminal justice system. At the heart of this innovative legal feature lies Article 411(1) bis of the Criminal Procedure Code, which mandates the public prosecutor to notify both the accused person and the victim about the submit dismissal request. This crucial notification serves as a beacon of transparency, affording all parties involved the opportunity to access the investigation file and present their case with a stipulated time frame of 10 days. However, the constraint imposed by this compressed timeline raise legitimate concerns about the adequacy of the defense preparations. 10 days may prove insufficient for securing legal representation, reviewing voluminous case files, and conducting thorough investigation. Thus, it becomes imperative for us to strike a delicate balance between expediency and procedural fairness, ensuring that all the parties are afforded a meaningful opportunity to present their argument to the judge. Moreover, the decision-making process following the submission of an opposition warrants careful consideration. While attendance at the subsequent hearing in chamber is not mandatory for any party, the judge's ultimate determination carries significant ramifications. Whether to dismiss the case or return it to the prosecutor for further investigation hinges upon a nuanced evaluation of the evidence presented at the unique circumstances of each case. Yet, amidst this deliberative process, questions abound regarding the role of the victim and their wishes in dismissal proceedings. Some argue that sidelining the victim's preferences undermines their rightful place in the legal proceedings. Conversely, others contend that empowering victims to make excessive claims detracts from the overarching goal of achieving an early resolution of the proceedings. In navigating always these complex legal waters, we must remain steadfast in our commitment to upholding the core tenets of justice and fairness, the constitutional imperative to allow both the victim and the suspect the ability to request a hearing in chamber underscores the importance of an adversarial process in determining the accused's responsibility. Furthermore, we must reckon with the fundamental rights enshrined in our Constitution, including the inviolability of the right of defense and the presumption of innocence. Any decision based on unnatural evidence gathering by the prosecutor runs afoul of these constitutional principles, necessitating a re-evaluation of our dismissal procedure. In light of this consideration, I think that two potential solutions emerge. Either reformulating the rules to require informed consent from the person under investigation, or granting them the right to oppose the dismissal order. By empowering individuals to actively participate in the decision-making process, we can ensure that dismissal proceedings remain in alignment with our constitutional imperatives. As we navigate the complexities of these dismissal proceedings, let's remain steadfast in our commitment of upholding the principle of fairness, equity, and justice for all. Through thoughtful deliberation and judicial decision-making, we can chart a course towards a legal system that truly serves the needs of our society. Thanks for your attention.
Thank you very much. Thank you for keeping time discipline. And I think that during this paper we have heard a lot of interesting and interconnected issues regarding the topic of your presentation. And thank you for sharing the Italian experience regarding the issues you have shown us, the dismissal for particular opportunity of criminal act. And I think we can move on to another. Thank you very much once again. And I think we can move on to another presentation. It's supposed to be Professor Andrea Castalda. However, we have a substitution with PhD candidate Mattia Cutolo, who's going to present the paper entitled Efficiency Within the Public Administration and the Abuse of Power Offense, a Substantive Criminal Law Approach. The floor is yours.
Thank you very much, Professor. Thank you very much, Professor Janusz-Pohl, for organizing and inviting Professor Castaldo at this very distinguished event. On behalf, of course, of Professor Castaldo, I bring his apologies because he, due to personal issues, he could not attend to this meeting, even though he really wanted to. So I will directly delve into his paper, which is entitled "Efficiency Within the Public Administration and the Abuse of Power Offense: A Substantive Criminal Law Approach." The framework of insecurity that affects the daily actions within the public administration on one hand, and its corresponding connection with the offense of abuse of power on the other, constitute the driving force behind this intervention. Within the criminal law context, the promotion of efficiency within the public administration and the simplification of procedures emerge as a fundamental principles to ensure the smooth functioning of state institutions and to promote social equity in the allocation of public services and resources. However, these objectives must be related to the offense that, for excellence, par excellence, protects the proper functioning and impartiality of public administration, the abuse of power offense. The intervention is aimed at clarifying the relationships between the concept of public administration's efficiency and, on the other hand, the offense of abuse of power. we call it in Italy abuse of office, basically. In order to understand whether the offense in question aids the public administration in its action, or whether it slows it down, or whether a fair balance is actually achievable. First, some brief considerations will be made regarding the structure of public administration within the Italian context, before moving on to a specific understanding of efficiency. Subsequently, the relationship between abuse of power and administrative efficiency will be investigated in detail. Finally, to conclude with a pars construens, the Castaldo-Naddeo proposal for the reform of abuse of power offense will be presented, aimed at, on the one hand, mitigating and making the offense more foreseeable, predictable, and on the other hand, not frustrating, but instead enhancing the efficiency prerogatives of public administration. The Italian public administration constitutes a complex organization system with tasks oriented towards pursuing objectives of public interest according to the standards of impartiality and proper functioning prescribed by Article 97 of the Constitution. This system comprises a body of professional officials supported by material and financial resources distributed across a multitude of legal entities and interconnected subject figures through various relational models. Firstly, it's important to mention that the diversified typology of public entities, including state, regional, and local bodies, each with specific functions and activities aimed at common good. Additionally, there are publicly owned joint stock companies and other entities that in certain areas operate as public law bodies. Generally speaking, one could be considered a public official if they work in these entities or assume a public role by virtue of being invested with functions in general interest. It follows that public administration is a political and social phenomenon reflecting the complexity of modern society, as it plays a crucial role in the interaction between policy and society. Within such context, the efficiency of public administration refers to its capacity to achieve predetermined objectives with the available resources, minimizing waste and maximizing results through discretionary powers. A performative public administration is capable of delivering public services in a timely, transparent, and citizen-oriented manner, ensuring a high level of satisfaction and effectively meeting the needs of the community. The evaluation of efficiency can be conducted through indicators such as response time, cost reduction, quality of service delivered, and user satisfaction levels. To define its scope, two main perspectives can be distinguished in defining efficiency. A technical one linked to productivity and resource management, and a deeper one focusing on adequacy and suitability in achieving desired result. Dwight Waldo describes efficiency as the ratio between the effects actually achieved with the available resources and the maximum possible effects with the same resources. On the other hand, there is a conception more rooted in Western thought, which associates efficiency with the Aristotelian concept of efficient cause. In this sense, efficiency is seen as the adequacy in achieving an objective representing a contribution to its achievement rather than a mere relationship between resources and results. In this perspective, efficiency is interpreted as the aptitude for office, Jeremy Bentham's famous definition, namely the capacity and suitability of an official in relation to their duties. These two views of efficiency can coexist, and they are not reflected in the constitutional principle of impartiality and proper functioning of administrative action. Article 97 of the Italian Constitution requires that the organization and rules of public administration ensure impartiality and good functioning, proper functioning. Efficiency, therefore, is configured as a set of instrumental requirements for the accomplishment of administrative tasks. In legal practice, this interpretation assumes relevance as the effectiveness of the administrative apparatus in achieving its objectives. The Italian Constitutional Court, while not precisely defining the contours of proper functioning, interprets it as a final objective of administrative action, looking at efficiency in a qualitative rather than quantitative terms. In conclusion, the concept of efficiency concerning public administration, following Article 97 of the Constitution, is evaluated based on its ability to achieve predetermined objectives rather than the simple quantitative relationship between input and output. Coming to the core of the intervention, the investigative focus concerns the offense that is most capable at the same time of both protecting and undermining the performance of public administration. I refer to the offense under Article 323 of the Italian Criminal Code, structurally built upon the violation of the laws governing the administrative action and the abuse of power by officials who knowingly deviate from such laws. Going step by step, it must be observed how the 2020 Italian reform, still in force in Italy today, has modified the offense by punishing the conduct of the public official who, by violating specific non-discretionary rules of conduct expressly provided by law, or by omitting to abstain from conflicts of interest, intentionally obtains an unjust advantage for themselves of others, or causes unjust harm to others. On this point, at least two orders of problems arise, of which I will give an account. The first, the widely practiced error, mistake, culpably or intentionally, consists of considering the offense of abuse of office or abuse of power as the only tool available against wrongdoing within the public administration. It's either criminal or nothing. Tertium non datur, Latin for there is no third option left. This is a demagogically effective yet legally misleading and incorrect approach. Not only is the repressive criminal apparatus of our legal system a lethal arsenal at the disposal of the investigating authority, but above all, the violation of rules governing proper administrative conduct finds perhaps even more effective sanctions in terms of deterrence and stigma. I refer to the administrative misconduct and public accounting misconduct. The second problem, the described phenomenon of the methodical expansion of the scope of abuse of power offense has ended up creating, or rather recreating, because we had several reforms interesting the abuse of power offense, a high number of criminal proceedings for the offense under Article 323 of the Criminal Code. The fear of facing criminal proceedings on the part of public officials or those entrusted with public service tasks has led to the well-known and analyzed effect of the flight from the power of signature, the so-called defensive administration. In other words, the public agent refuses or delays, thus postponing making the decision within their competence for fear of an error or mistake so severe that it would cost them the initiation of criminal proceedings for abuse of office. This refractory, reluctant attitude is directly proportional to the quality, weight, and subjective position held. The higher one climbs the hierarchical ladder, the less one witnesses the promptness of decision-making output. At this point, it can be reasonably argued that among the causes of the flight from the signature phenomena, there are precisely legislative confusion, role overlap within bureaucracy, numerous regulatory sources, and the lack of a meritocratic system in the administrative apparatus. Allow me finally to make one last empirical statistical reference. In Italy, criminal proceedings based on Article 323 of the Criminal Code have an extremely desolate conviction rate, as summarized in the results of an analysis conducted by 7 universities coordinated by the University of Salerno regarding criminal proceedings in the district of the Court of Appeal of Salerno in the 5 year 2014-2018. Here are the data. Out of a total of 180 definitive decisions issued in the various phases of the trial, only 17 convictions for abuse of power offense are recorded. According to the Italian National Institute of Statistics, in 2017, there were over 6,500 proceedings opened by prosecutors for abuse of office, with 57 people convicted by final judgment. Furthermore, according to the Ministry of Justice data, in 2021, out of 5,418 proceedings defined with special procedures before the judge for the preliminary investigations, there were 4,613 dismissals, of which 148 for prescription. As for conviction, there were 9, with 35 plea bargains, while 370 decrees order trials. So there were 370 trials at least. At the outcome of trial, then, out of 513 proceedings defined, there were only 18 convictions, compared to 37 in 2020 and 54 in 2019, whereas there were 256 acquittals. Ultimately, the correlation between the efficiency of the public administration and the offense of abuse of power rests on 2 distinct profiles, a positive and a negative one. In fact, such offense protects a well-functioning and impartial administration towards citizens. Indeed, an efficient, ineffective, or negligent administration increases the risk of abuse by its official. On the other hand, the offense risks subjecting the efficient public official to criminal proceedings due to every minor violation, with the consequence that they may prefer to restrain this decision-making and avoid flee the power to sign, delegating to others the question of the legitimacy of the act. Mostly, of course, we are talking about courts and judges. Lastly, on one end, when administrative procedures are opaque, controls are weak, and responsibilities are unclear, public officials may be tempted to act arbitrarily or unlawfully to achieve their personal goals or to favor third parties. In such cases, the lack of efficiency in administrative action can facilitate and encourage abusive behavior, jeopardizing the integrity of the system and damaging citizens' trust in the administration. On the other hand, however, a broad and serious offense, such as the abuse of office, could freeze administrative action with the fear of applying the signature to public documents by the public officials, because the official is not placed in a position to know before, ex ante we say in Latin, whether or not their efficient action, for example, the signing on time of public acts, risks falling within the scope of the offense of abuse of office. I'm closing down on the intervention. Finally, as part of an academic project led by the University of Salerno about the performance of public administration and the role of the abuse of power offense, a proposal is presented for the restructuring of the offense with the aim of providing a legal framework that exclusively sanctions conduct actually harmful to the public administration and in its impartiality and proper functioning, as indicated in Article 97 on the Italian Constitution. Such proposal for the reform of the abuse of office offense aims to redefine the three fundamental elements of the offense: the conduct, the event, and the subjective element. Regarding the conduct, it is proposed to limit its scope to violations of formal laws, excluding interpretation of constitutional principle and references to primary sources. Additionally, it is required that the laws of regulation specified in the charge of abuse of office can be specific to the sector in question. This would allow for a targeted selection of the normative resources essential for the proper exercise of public function, avoiding that every violation committed by a public agent could constitute abuse of office according to Article 323 of the Criminal Code. Concerning the harmful event, in addition to the requirement of double injustice, which means the violation of the law of conduct and the unjust harm or enrichment of the public official, it is proposed to require a risk link between the conduct and the event itself. In other words, not every unjust financial advantage or harm would be considered abuse of office, but only those intended to be prevented by the violated normative source. Regarding the subjective element, the mens rea element, the proposal introduces a mechanism of preventive control for more complex cases. As to the relevant case law, compliance with the guidelines established by an independent administrative regional authority would become fundamental in determining the liability of the public agent. Although it would not directly influence the objective element, the conduct or the event, this mechanism could affect the mens rea element, in particular the intent. The aim is therefore to protect the actions of those public officials who, while making mistakes during the administrative procedure, do not intend to cause unjust harm to others or obtain unjust advantages for themselves or others. And closing down, the most innovative aspect, also overlooked by the 2020 reform, concerns the introduction of a risk link between the conduct performed and the harmful or advantageous event that results from it. In this sense, for the configuration of the offense of abuse of power, it is necessary to violate norms aimed at preventing an event typologically similar to the one that occurred hic et nunc, Latin for here and now. The aim is evidently to exclude merely formal violations following interpretations already proposed by legal doctrine. Thus, this intervention is concluded by specifying how an efficient public administration is only possible to the extent that the official is placed in a position to carry out their role without leaving legitimate, moreover, a fear of incurring in criminal sanctions. If this were not the case, as seen, the public official would do everything possible to flee from the signature, resulting in the immobilization of the administration. The proposal here put forward is precisely characterized by the so-called risk link between the violation of the non-criminal law concerning the administrative procedures and the harmful event of abuse of office. This choice goes, in fact, in the direction of a public administration protected by the criminal offence in its constitutional prerogatives of impartiality and proper functioning, and at the same time efficient, as a criminalization would be limited to sanctioning only truly offensive conduct, leaving within the realm of criminal lawfulness a whole series of physiological error mistakes that should never hinder the bureaucratic machinery from continuing to carry out its functions. Thank you very much for listening. I'm available for questions if there are any.
Thank you very much for your paper, for your presentation. Once again, we were presented with interesting and insightful paper about complex and serious issue. The abuse of powers or the abuse of office is a common problem for all types of legal systems or countries. Presenting new solutions for increasing efficiency of fighting that offense are always welcomed and inspiring for others. So let's move on to our speaker, another paper. Please welcome Cristina Madrid-Boquin, representing Jaume University. She's going to present a paper entitled Exploring Paths for Consumer Protection in Spanish Civil Court Judgments, Individual or Collective Actions. The floor is yours.
Thank you so much. Thank you, Professor, for this kind introduction. I would like to just take a brief moment to congratulate the heads of the project, Professor Barbara Janusz-Pohl, Professor Daniele Vicoli, also to congratulate the organizers of this magnificent conference, especially to Michał, and special greetings also I would like to send to Professor Steve Thayman. Today I have mixed feelings because I wish I could have been there in person, but this was not possible. But I am still very happy to be joining you online. Just one moment so I can share my presentation with you. Please just let me know if there's any problem. I think you can visualize it now. Today I will be speaking, thank you, about the paths for consumer protection in Spanish civil court judgments and considering the duality of combining individual or collective actions in order to get the procedural protection that is being sought by the consumers. So the Spanish Civil Procedure Act contains regulations aimed at protecting the rights and interests of consumers and users. And as we all know, it is a relevant matter nowadays due to the numerous quantity of commercial relations that are established in our society. In this law, the legislator refrained from setting a special process for these type of cases and instead chose to define a variety of specialities that affect procedural requirements such as jurisdiction, capacity, standing, and other aspects like the joinder of proceedings, the effects of the judgment, or the powers of the parties in the enforcement phase. In this presentation, we will explore two procedural paths for the protection of consumers. First, the collective actions, which, as you know, allow a group of affected persons to appear as parties in one same procedure, which will be resolved in one single judgment, granting the legal protection requested by the group, by a collective. The second path is a new legislated figure that is called the witness procedure, and this enables the selection of one individual case to serve as a reference and whose judgment can be later applied to other individual cases that are subsequently decided as long as they refer to a substantially equal claim. In both matters, and for time's sake, we will focus on the effects of the procedure, that is, on how the judgment issued in one particular case can or cannot be applied to other consumers different than the original parties or to subsequent identical cases. So, for the first path, in relation to collective actions, we must first consider that the Spanish Civil Procedure Act gives capacity to be a procedural party and recognizes standing to appear before court to, first place, to individuals, that is, individual consumers of goods or uses of services that have been affected by a damaging event. In second place, to groups of consumers or users, as long as they are constituted by the majority of the people who were affected by the events. In third place, to associations of consumers and users, which can defend the rights and interests of the association members, but they can also represent the general interests of consumers and users. So in other words, these consumer associations can appear in court representing either collective rights and interests or diffuse rights and interests, in this later case when the group is not specifically determined. And finally, the capacity to be a procedural party and the standing to appear before court is also recognized to legal entities that have been authorized by EU law and also to the Public Prosecution Service. Thus, we can see how collective actions are characterized by the fact that what is being sought through the litigation is the protection of a group of affected people. In some cases, these persons are specifically determined, name, last name, etc. But in other cases, due to the nature of the facts, it is not possible to determine each and every affected person. For this reason, the law establishes rules regarding the effects of the proceedings. So here we have two specific articles they are both from the Civil Procedure Act. In Article 221, we can see how it states that when individual consumers have appeared as parties in the proceedings, the judgment will expressly issue a ruling that refers to their pleas. Nonetheless, when the judgments are issued in proceedings brought by associations of consumers and users, different rules will apply. First, the judgment upholding the claim will individually determine the consumers and users who can benefit from the decision. However, if this is not possible, then the judgment will include the details, the characteristics, or the requirements that will later enable the enforcing court to determine if a person can require payment or can apply for the enforcement of the judgment or become a party to the enforcement that has already been sought by the consumer association. The second rule states that in the specific case where the judgment declares that an activity or a conduct was illicit, then it will determine whether the procedural effects can extend beyond those who had been a party in the corresponding proceedings. Then as a complement, we have Article 519, which regulates the enforcement action for consumers and users when the conviction does not determine individual beneficiaries. Regarding this article, and on the one side, when the judgment does not refer the individual consumers benefiting, then the person or persons who are interested in benefiting from that verdict, they can present an enforcement claim to the court. The court will then decide if the applicants are beneficiaries of that judgment according to the requirements that were indicated in the same judgment. On the other side, the enforcement of judgments protecting collective or diffuse rights can be sought by the association of users and consumers, as we had mentioned before, if the association participated as a party, as a claimant party, and it can also be brought by the Public Prosecution Service. So, in short and by way of summary, we can indicate that the judgment will affect, as a general and preferential rule, specific consumers and users, that is, specific persons. However, if the nature of the claim does not allow this determination to be made, then the judgment will indicate details, characteristics, or requirements that will allow the later identification of beneficiaries, and this will be verified when the court is enforcing the judgment. Consequently, a person that was affected by facts that were the subject of the judgment and who may benefit from it can request the enforcement or join an enforcement that was already initiated by another legitimate party, and so they can obtain the judicial protection granted by a judgment. In any case, in order to obtain this judicial protection, the action of the interested party is necessary, and she must intervene whether in the declaratory process or in the later enforcement process, in accordance to the principle of requested justice. Then we have the second path that we mentioned for protecting the rights of users and consumers. This is a new legislative act that was passed last December. So it's in Royal Decree Law number 6/2023. This is part of a larger set of reforms that have been proposed and that the legislator has been working on for the last couple of years. However, since it is very complex, it is all aimed to efficiency. Just one part of this reform has entered into force related to digital efficiency, and as a part of it, this witness procedure was also included. So in this recent years, the Spanish lawmakers have recognized that a serious problem arises from mass litigation in the area of general contracting conditions. The massive volume of cases that are being brought before the courts has often led to their collapse and dysfunctionality. So incorporating the new witness procedure, now regulated in Article 438 bis of the Civil Procedure Act, is an innovative tool both for the courts and for the litigants. This figure has already been applied in the contentious administrative jurisdiction, but is new to the civil jurisdiction, and it seeks to respond to claims that are substantially identical in their subject matter, that is, different people having one same consumer or user problem. And therefore, we won't need to process all of them, but we can use this witness procedure system that will be a kind of joinder of proceedings that will permit to homogenize the decisions being made by the courts. So how does it work? It will first be proposed either by the court clerk or it can be requested by one of the procedural parties, and this will allow the judge to select one case that will be tried on a preferential basis. It will be a referent case. Thus, the other cases that are basically the same claim but brought by other individuals, these other cases will be suspended during the course of the witness procedure. The conditions necessary for the application of this witness procedure system are, first, that the case must consist of an individual action, that is an individual, a person as a claimant, an individual action relating specifically to this topic, to general contracting terms and conditions. The second condition is that the general contracting terms and conditions in question have to be substantially identical in the witness procedure and in the other related, let's call them the other related cases. And the third requisite is that it must not be necessary to examine the transparency of the clause or to assess the existence of defects in the consent of the contracting parties. So, 1 minute. I think I run my slides too quickly. Okay, here we are. Okay, so once the judgment in the witness procedure has become final, the court will indicate if it deems appropriate to continue or to suspend the other proceedings. And this will depend basically on whether all the issues have been solved also for the related proceedings, or if there are any issues still left to work out during the other cases. So the applicant from the suspended proceedings will be given notice, and this applicant from the suspended proceedings will decide whether if they will apply for the withdrawal of the claim, or if they will ask for the continuation of their proceedings and indicate the issues and arguments that are still unresolved, or third option, if they will apply for the extension of the effects of the witness judgment to their own case. Then, in addition, through the reform, Article 519 was also amended to regulate the conditions that are necessary to extend the effects of the witness judgment to other proceedings that have been suspended. In this case, we have additional requirements that are basically that the proceedings involve the same defendant or the person who succeeds him in his procedural position, that the sentencing court is responsible in both cases by territory, that is, of the witness case and the other related case that had been suspended, and finally that the application must be made within a period of 1 year after the witness judgment has become final. So, in conclusions, where do I think that we stand with these two paths for consumer protection? As we have seen, the witness procedure will necessarily refer to an individual action, referring to general contracting terms. The witness proceeding, therefore, cannot refer to collective actions. Moreover, we can conclude that this type of procedure is incompatible with collective actions. So, a judgment handed down in a witness procedure cannot extend its effects to subsequent collective actions and vice versa. A procedure that was based on a collective claim cannot serve as a witness judgment to extend its effects to other identical cases. Therefore, the witness procedure and the collective actions are differentiated paths between which the group of consumers and users will have to decide. It will depend on the circumstances of the cases and whether the individual or the group chooses to take one or another route. In general, I welcome the idea of incorporating this new witness process, which could, if it was properly applied, reduce the number of cases with substantially identical claims, providing therefore an efficient and possibly faster and also effective response to consumers and users. However, the reform will require investing in resources, both human and computing resources, because filtering and processing the work to determine the witness procedure system will involve an added workload. Furthermore, it has been considered by academics that the near automatic resolution of cases can result in a failure to consider the particularities of a matter at hand, and it will limit the intervention of the parties who could possibly have to accept the result of proceedings in which they were not able to participate or to have the complete information right up to the conclusion, that is, until the judgment has been made final. In any case, I stress the importance of respecting the freedom of those users and consumers affected in relation to the exercise of their constitutional right of action, and to allow them to request to apply to the court in case they opt for one or the other procedure, and to allow them to object to the application of the witness system to their particular case. And with this thought, I finish my presentation, and I will be happy to receive any questions or comments at the end of the panel. Thank you very much.
Thank you very much. Thank you for providing the details of the Spanish civil procedure regarding the protection of customers to us all. It is certainly a very timely topic, as the author herself pointed out, due to the intensity of relationships in the society or the market, as well as to the asymmetry of situation between the provider of goods and services and the customer. There's a need to find a just procedural solution to solve the disputes between them. I think we can move on to another speaker, another topic. Please welcome Koidu Saya from Tallinn University of Technology. Yes, welcome. She's going to present a paper entitled Life Path Lessons of Child in Close Childcare Institution Service in Estonia, Experiences and Practice Related to Interprofessional Collaboration-Based Support. The floor is yours.
Thank you. I hope you see my slides. Yes, thank you very much. My name is Koidu Saya. I'm from Estonia, from two universities, so that from Tallinn University of Technology, where I'm working as research coordinator, and also from Tallinn University, where I'm working as a researcher in CIRIC research group, which is focused on children and family well-being studies. And just, I also wanted to say in the beginning that I'm very grateful for the opportunity to present the study. And as I also already have listened and heard that it's very justice focused, but I hope that also I can enrich this panel with some kind of child protection focused topics. And you can find something also interesting for you, because I already linked my topics with the presentations I heard. So something about my professional background. It's social sciences, social work, social protection and child protection, and I have been also working as practitioners quite many years, working with children in dually involved children, these children who are in between of child protection and juvenile justice system. And also 2 years ago, I defended my PhD thesis, which was focused on interprofessional collaboration in social rehabilitation service for dually involved children in Estonia. And also I brought here one slide so that our CIRIC research group is really doing different studies relevant for Estonia, but also international studies. And today I will present some results from one of our previous study. Also some words maybe about Estonian context. Of course, Poland and Estonia, we are not so far to each other, but for example, maybe some details that our population is 1.3 millions. 1/3 of our populations are children. And also maybe that Estonia is quite well known about digitalization, different public services, e-services, and also all tech-related solutions, which are also part of our child protection system and also part of our everyday life. And also because of it, we are also making research on it. My focus today will be on children in closed institution service. I will focus on experiences and practices. And also, like, my special focus is on interprofessional collaboration related support, which we can provide for our children. The study where all these results are related to, it was conducted some years ago. The main results were reported last year, but they are quite relevant also today, so that nothing very much has been changed. Big changes took place before we did this study, and also this was a reason why Estonian Social Insurance Board ordered that kind of study piece. And also I didn't do it alone, so that our CIRIC research group contains different researchers from Estonia, but also from different disciplines, and also abroad. And also juridical field, law field is also one part of it. Something about what we did about this study. So that this analysis is part of a larger 3-objective study, and this concrete sub-study carried out under the responsibility of our research group, and was aimed to analyze the cooperation between the child protection, education, social and law enforcement systems for the benefit of children in the CCIS, so the closed care institutions for children, including identifying bottlenecks in the system and possible solutions. Of course, we started with a systematic review to get also the international practices, picture about international practices concerning CCIS. And we especially looked UK, Norwegian, Netherlands, Denmark and Ireland's best practices, different practices and models, which were related and targeted to CCIS target group or similar children with similar needs. And we tried to also understand that what kind of key factors we could identify based on hundreds of research articles and different also grey literature and also research reports. And what came out that the keywords and key factors how to support these children in closed care institutions. It's important to focus on positive parenting, prevention and early intervention and identification of families and children at risk. Also to support participatory approaches. It's important to be child-centered, to encourage children to express their needs and wishes. Also, child safety models and programs were important, and focusing on family strengths and skills. And of course, this topic, which is especially interesting for me, also that literature showed and proved that interdisciplinary collaboration as an integrated method for agencies and professionals to work together to identify risks early and provide effective support. It's also one important key factor. We describe the Estonian context, so that maybe what is important today is to what I can describe a little bit was that in 2018 big reform in Estonian child protection and the Estonian welfare system took place, so that and it was the replacement of special schools, so that this was the title or name, how we named these closed institutions, which basically were almost like prisons. So that the change came in, so that after 2018, the focus is more on restorative justice, child-friendly justice, interdisciplinary collaboration, rehabilitation, and so on, and also mental health issues, of course. So that significant changes have taken place in Estonian child protection, education, social welfare, justice systems in recent years. And these changes have affected the well-being of children and families in vulnerable situations, but also have posed new challenges for professionals working in the system, also for sector developers and policymakers. What is special in this CCIS service is that children's fundamental rights are significantly restricted, so that it's not a prison, but basically their rights are very restricted, and the assessment and decision-making process that underpins referral to services, it takes place based on Social Welfare Act, so that by child protection workers, or through criminal procedure. And all this process is complex, and it definitely affects the lives of both the children in need and also the family. The aim of CCIS service is to support the child's psychological, social and emotional, also educational and cognitive development in order to achieve lasting changes that will enable the child to cope successfully in the normal environment after the end of the restriction of the freedom. And the special attention is on health issues, and also how to change the contexts, like home context, school context, health conditions after the child will return to home and the regular life. So that during this approximately 1 year, this service lasts usually at least 1 year, it provides temporary 24-hour support and security for a child whose behavior poses a serious threat to their own life, health and development, or can be dangerous for the others. Who are these children in Estonian CCIS service? The main reasons for referral are the following. The child is violent and aggressive towards other people or property. The child abuses addictive substances. The child has a history of risky sexual behavior. The child has a long history of truancy. The child has a history of non-consensual overnight absences, so that doesn't stay at home at nights. The child is violent towards themselves, for example, cutting themselves or attempting suicide. And usually different these conditions and factors are combined and long-term and systematic. The service is not suitable if a child needs constant medical supervision and intervention because of physical or mental health conditions, for example, acute psychosis. How this service works. The service provides a structured environment which is supportive, caring, and organized in a meaningful way. The child's time usage is regulated and systematic, so that there is time for sleeping, being awake, studying, physical activities, screen time, and so on. Also, special attention on trauma recovery. It's very important to support the child and also the family, and also to build up new attitudes, new skills, and new strengths. Also, for example, new friendships and relations, so that the child and family can make the changes. In the end of the first year, when the person and child is in the service, there is also a period to give more freedom, so that more activities outside to build this trust and also responsibility. And also taking all this into account, it's very important that that kind of support is complex and it's based on a multidisciplinary, highly professional, well-functioning collaboration. We had 4 basic theoretical frameworks what we used. Reeves, Lewin, Espin, Swarenstein model about cross-disciplinary, cross-functional teamwork. We had Pinkham model to understand this interdisciplinary collaboration and perceptions, child-friendly approach, and child-centered approach. We did individual and group interviews with children, parents, service managers, counselors, different policymakers, judges, network members, and used thematic analysis to analyze the data. The main results where we got or what we received were the following. It's very important for the child and also for a family and also for the network to be informed, so that the content, process and timeline of this service, which is a very serious service, that the family has beforehand already this information. It's important to work with the environment and relations where the child will return to. Also, it's important to find the motivation or help to grow this motivation inside the child, especially, and because then the participation in this service is meaningful and makes changes. Also, the power issues are really important, that the child and family doesn't feel all the time that somebody knows more about their lives, but with understanding and supportive relationships and also open communication in the networks. Also work with a wider context that the school and also healthcare system and all these contexts where the child will return and continue his or her life after making these changes in this service in his or her life. It's important that also the context could be supportive and supports these changes. Also, we understood that the case management by the child protection workers doesn't work very well all the time, so that there were many cases when the child was in the service, but the case was like not active during the service provision time, and if the child returned, then the context and the environment was not ready, and relations were not ready for it. Also important is to find the trusted person for a child, the adult person whom she or he really can trust if there is not enough support by the family. Labeling is a problem, but for example, if a child from this service returns to a school, then already there are stigmas around him or her. Also, one very big problem that in Estonia we don't have too many complex services which support children in different angles, for example, from medical and mental health and educational needs and so on. And this service, CCIS, was also sometimes used as the rescue service, which covers all these needs, but it was not meant for this. So that it's important for municipalities and also for the state to provide similar services, but not to use this CCIS service to replace the lack of services what we sometimes have. And also important, what is very important, that with that kind of services, it's not possible, it's not the right way to threaten the children before the service, that, for example, if you don't go to school, if you steal from the shop and so on, then you will get to the CCIS service. So that the balance, how to really make it useful for the family and children, and also to not be as the punishment for the child and family. It's a quite fragile balance how to find it. And also, like the key issue that this meaningful involvement of children and parents and family, this is the key issue and aim where all these interdisciplinary teams has to work on with. And also some practical implications, so that in order, and it's based on this systematic international literature review and also based on Estonian cases, what we studied more deeply. In order to notice cases where assistance is needed as early as possible, it is necessary to make early identification in CCIS families, related institutions, a part of everyday work. It's also very important to increase the availability of mental health services and the client-friendly and non-judgmental treatment and help for children and families in need. It's also important to work with these children in child-friendly, trauma-informed way, and not only by child protection workers, but also by prosecutors, for example, by court and so on, by police. The decisions must be understood and acceptable to all parties involved, and the child and family has to be involved at all stages. and the solutions must sought in full collaboration. And it's clear that in Estonia, there is a need for a wider selection of open care services for children with specific needs. For example, children who are in juvenile justice system, but also who has intellectual disabilities or mental disorders. It's also important to build up timely home type assistance for families and also treatment home type institutions. So that thank you very much for your attention. You are always welcome to visit Estonia, visit Tallinn, and also Tallinn University or Tallinn Technical University. And I'm located in the School of Business and Governance. So that thank you very much.
Thank you very much for sharing the results of your research with us regarding closed child institution services in Estonia. Estonia is not so far away from Poland, not so far away from Białystok, where I'm living right now. Well, the fate of the youngest participants in the legal proceedings should always be at the center of our interest in the administration of justice. It does not matter what role they play in those proceedings, as perpetrators or victims. From my point of view as a criminologist, the contact of the youngest citizens with the administration of justice in various aspects is important and can have serious consequences to their further adult life. So that was very interesting, especially for me, that's your presentation. And let's move on to the last paper we have scheduled for today panel. It's going to be a recording presented by Lisa Ria from Restorative Justice International, Challenges to Restorative Justice, Joint Actions by Restorative Justice International. This is an NGO organization. So I'm kindly ask organizers to play the recording.
And I am the president and founder of Restorative Justice International. And we are so pleased to be presenting today at the Adam Mickiewicz University there and the Effective Justice Conference. And we're pleased to work with Professor Barbara Janusz-Pohl at the university, who's a member of our Global Advisory Council at Restorative Justice International. I'll mention that a little bit further into my presentation. So I should be speaking approximately 15 minutes at your conference. So a little bit about my background. I have over 25 years of restorative justice experience, but before that time, I had a strong background in public policy. I've worked in the California legislature on staff for 3 members, both in the Assembly and the Senate. And I also served as a subcommittee consultant on welfare reform. Most of my background before I got into restorative justice was public policy, but not related to justice, criminal justice reform. It was related to all kinds of issues, including environmental public policy, welfare reform, and also labor. So I've been a legislative advocate also for many organizations, both in the public and private sector. And with my restorative justice work, I got into this field in the 1990s in California, and I was first the state director of Justice Fellowship, which is a sister organization of Prison Fellowship that focused only on bringing restorative justice into the criminal justice system in California. I worked for Prison Fellowship International as a consultant, and that's where I actually got my feet wet, as you say, internationally, and learned about how much restorative justice work was happening around the world. I then started a nonprofit in California called the Justice and Reconciliation Project, JRP, and our work was, like I said, it's in California, but national, and we worked with victims of violent crime in particular. And also, just lastly, and I'll mention this a little bit more in detail later, through Prison Fellowship International, I was lucky enough to be the director of a project called Sycamore Tree, and that was actually in 1998 in the state of Texas, and I'll talk about that later. Okay, so Restorative Justice International. I was asked to talk about some of our achievements, and let me just describe the organization. First of all, you can go to our website, restorativejusticeinternational.com. I founded the organization in 2008, and a lot of it was, the reason I did that is my own international contacts, many of them through Prison Fellowship International, that there was great interest in this field, and it was kind of coming together through social media. So I ended up founding the group through LinkedIn, and we're an advocacy organization which focuses on bringing restorative justice to bear on our justice system. We now have over 7,200 members and affiliates from around the world, including human rights experts, former UN diplomats, academics, crime victims, ex-offenders, public officials, researchers, exonerees, universities, and law schools. And again, go to the website and find out more. There's a listing of our affiliates there. And we've developed our 19-member Global Advisory Council, which you can find online, with esteemed members from the following countries: Poland, Brazil, Thailand, Australia, the UK, South Africa, Ireland, Nigeria, Spain, New Zealand, and the United States, with many members from the United States, from various states. We meet virtually during the year to discuss global challenges and issues of the day in need of restorative justice. Those meetings are often made public and may be viewed at our website. Those recordings are on the website under news. Okay, RJI advocates for victims-driven restorative justice when working for systemic reform of our criminal justice systems. So how do we define that? So victims-driven restorative justice stresses the need to put victims in the center of the system after crimes are committed. So restorative justice acknowledges that crime is against a victim, a real human being, and not seen as a crime against the state. This is a critical point. So that means that we stress offender accountability and the need to make things right with the victim or victims as much as possible. And communities are also in need of restoration after crime, because crime causes a lack of shalom, lack of peace in communities. So RJI has produced over 60 international podcasts on a diverse array of subjects in the field, expanding the use of restorative justice wherever there is conflict, violent crime, and even war. You can find those podcasts on our website. We have been very active politically in the last few years, endorsing candidates who support restorative justice, or those who are in office that we think are doing a good job and that they support restorative justice. So those public officials are often district attorneys, prosecutors, in other words, and other public officials, including judges. You can see some of those endorsements on our site. Largely, we've done that in the United States, but we're interested in doing it internationally. So then we created something called the RJI Hubs. This was a way of organizing our membership and affiliates according to subject area. And it just shows the diversity of our work. So these are some of the hub areas, and these are on our site too. So I'll list them here. Number one, advocating for victims' right to restorative justice. This is a real critical point, and it's something that restorative justice advocates and organizations around the globe, we feel have not been stressing this. We think there's a need to give victims the right to restorative justice. So that would be in statute, and that's something that we think is necessary in order for victims to access restorative justice. Secondly, we support applying restorative justice to wrongful convictions. This is a new area for us, but we've been involved probably in the last 5 years. We have someone who is exonerated in the state of New York, Jeffrey Doskonała, who sits on our council. But it's important to apply restorative justice to wrongful convictions in any country, because when you get the wrong person in prison or jail, then you've created two victims. So we think it's important that restorative justice apply to these individuals, that they be paid restitution, and also there's an apology. But there's work and public policy positions that we take to try to end wrongful convictions, stop them from happening at the start. Number 3, restorative policing. So this is an exciting part of the field of restorative justice. It's taking the restorative justice principles and applying it to law enforcement. We believe that communities can be safer when restorative justice is used by law enforcement. There's a white paper that we generated about 7 years ago. It's on our website, and it was created by an RJI international committee that studied restorative policing. So we had quite a group of individuals, largely academics, who studied it through RJI. So there's a white paper that you can find under news and also a webinar. But this is an important way of applying restorative justice to communities. Number 4, we support in-prison restorative justice programs. I mentioned this at the start, a project called Sycamore Tree. So in 1998, I was the director of the first Sycamore Tree project in the state of Texas in a medium security prison. And what the project did is it brought surrogate victims and offenders together to meet over 8 to 12 weeks in prison to talk about crime, to talk about what restorative justice is and the need for it. And that project was an eye-opener for me because I have a legislative background. And I was asked to run the project by Prison Fellowship International and their Vice President, Dan Van Ness. And frankly, I didn't think I should be the one to run it. But once I directed the project, it was an eye-opener in terms of how restorative justice could apply to crimes, whether a person, an offender, was in prison or once released. So it was an incredible success. And it's, since that time, it's been replicated in approximately 40 countries. We support Sycamore Tree and other models like it. Okay, number 5, environmental restorative justice. We've done a podcast on this concept. Again, taking restorative justice and applying it to environmental crime or environmental harm. And it puts the emphasis on offender accountability and how those who harm the environment or contribute to even climate change, how they can be held accountable and how the environment can be seen as a victim. We did a podcast with a professor in Belgium, Dr. Brunhilde Paley, and that podcast is on our site. Number 6, this is kind of a new area where we're active, restorative justice and political extremism. And we worked with Professor Don John O'Malley in Nigeria, who sits on our council, who's written extensively on this subject. But it's the need to apply restorative justice to extremism wherever it's found in any country, and why restorative justice can be helpful in transforming offenders and changing their behavior. Number 7, the death penalty. We take a position in opposing the death penalty and its use around the world, and that is due to our position that crime victims that we work with around the world are saying that restorative justice is what they want, that they get no healing from the death penalty and its use. We work with a pastor who sits on our council. It's Reverend Jack Sullivan Jr., who's in the state of Ohio. He's active director of the Ohio Council of Churches. He's also a victim of violent crime and who passionately opposes the death penalty. You can find a podcast that we did on that subject. In fact, Professor Barbara Janusz-Pohl was on that podcast, and that's on our website with others that we called upon to speak. Number 8, evidence-based research and restorative justice. This is very critical to the advancement of restorative justice around the world, because in order to take a strong position in support of restorative justice and in our work around the world legislatively, you need good evidence-based research. And often when we find that evidence-based research, we post it on the website. Okay, I was asked also to speak about challenges for restorative justice today. I kind of mentioned some of them through my other comments, but let me just highlight a few here. lawmakers who still talk tough on crime, it often means that those politicians support incarcerating all offenders. We think that that's a mistake, but it's that type of talk that is harmful to the work that we do as we promote restorative justice. So the tough on crime political speech really offers no relief for crime victims. It does not reduce recidivism rates, and communities are not safer. And so therefore we say that's why restorative justice is needed. Number two, restorative justice is particularly important now since the rule of law is threatened in so many countries around the world. That's a subject that we talk about through some of our podcasts, and we bring experts from around the world to talk about that fact. Restorative justice is really about truth telling, and it applies to societal problems and ills, whether it's on the micro level or on the macro level. Number three, it's important to advocate for restorative justice when political extremism is more evident globally. I mentioned that before, but it calls on those of us that are advocates and experts in restorative justice to apply the principles to extremism. And lastly, there's need for further evidence-based research around the world and funding of that type of research, because the better we track the use of restorative justice cases, whether it's victim-offender dialogue cases or using restorative justice in other contexts, like inside prison. So that concludes my remarks for today, and it's wonderful to be here with you today, and I wish I could be there in person, but thank you for the opportunity, and take a look at our website for more information on us. Thank you again. This is Lisa Ray for RJI.
Thank you very much. I think I'm on. Can you hear me? Well, I'm glad that we have overcome some technical problems. Mediation is a relatively effective method of resolving disputes of a legal nature. Of course, it should be properly selected according to, for example, the nature of the crimes. However, it seems to me that we are not using its potential in full extent, at least in Poland. Probably different experiences of different legal systems, different countries come into play. When I look at the clock, we have 3 minutes, so it's not much. That was the last paper and the last speaker scheduled for today for this panel. I don't know if we have still some times to ask some questions, maybe one question. I don't want to stand between you and the coffee break because it might be difficult for me to stay alive. Is there any questions you'd like to ask our panelists? Please, you're invited to ask maybe one question. Maybe some statement or comments. Please share with us.
Okay, so as we now are at the point of coffee break, am I audible?
I can barely hear you.
I'm from here. Would you
Oh yeah,
me?
that's much better.
Thank you for your leadership in this panel. I know that it was challenging, and I would like to also add congratulations to all the speakers, because the whole agenda was, I would say, troubling, because there were some performers who didn't make this today, as Denise, and Denise's speech was in line with the speech of Koidu. So this changed a bit whole vision of the panel. But if I might comment, this panel was to show the extent of the goals of criminal justice, because we discussed the effectiveness from the point of view of the purposes for criminal justice. So this panel was to show that criminal justice mustn't be just concentrate on crime, but also what is connected with juvenile delinquency, or what is connected with the petty offenses area, as in the speech of Emanuela Madrid. So we do not have questions from the main hall, but we wish you, I think, nice discussion. Then we could be discussion on our chat if it will be needed. during the future, I would say, events and during the next panel, because we are waiting for the last panel and then official dinner. So I think that it's for now time to again, the floor is yours.
Okay, thank you very much. Once again, many thanks to all the panelists for sharing their knowledge and research with us. I also thank the audience for listening to these interesting and sometimes eye-opening papers. I'm sure they will become a springboard for your thoughts or inspire future research in that field or different fields. As you mentioned, there are some issues interconnected with each other. Furthermore, I consider my role as closed. Thank you once again. See you in person sometimes in the future. Thank you.
Hello everybody, good afternoon. Welcome to the last panel for today. The panel is entitled Organization of Judicial Systems, Part 2. It is the last panel for today, but I have no doubt that it will be at least as interesting as the previous ones, if not the most interesting of the panels for today. It is a great pleasure to welcome you all, dear speakers, dear audience, because I have to warn you in advance that we have to finish precisely on 5:30. I will just make a short introduction to the panel. So during this panel, during the 5 presentations, we will first of all, we will learn about the definition of effectiveness or efficiency in a criminal trial. Why do we use this concept and how do we use it? What does it mean in the perspective of a criminal trial? And the second notion, the second problem will be, why is it a governing perspective in this panel? Because many ideas on this will be given from different perspectives, also from the perspective of international criminal justice. And the first speaker will be Professor Janusz-Pohl from Adam Mickiewicz University. Who will define for us the terms of effectiveness, efficient criminal trial. Barbara, the floor is yours.
Thank you again. Thank you again, the floor is mine. I will try to be short. As first of all, this content, what I'm going to present, is a part of our book. So the book is soon to be published and there will be option to read entire chapter. So today, let's say it will be just some highlights, what is inside. And already you could use our great booklets with some essential content. So this also could serve us as some guidance for my speech. What I'm going to discuss today, these are, first of all, the connotation of 3 notions. As Professor Kuczyńska said, effectiveness, efficacy, and efficiency. Because it happens that based on many different approaches, in my work I try to dig somehow deeper to put this interdisciplinary approach. So I had a look on economic theories, philosophical theories, some psychological theories, how to perceive effectiveness and other relevant terms. And I tried to approach those understandings to create more consistent methodological field for perception of effectiveness in criminal justice. So what I would like to say at first, that my inquiries brought me to somehow renewed understandings of effectiveness, but what is more, they confirmed some intuitions of understanding of the effectiveness by lawyers, which are often used without any clear background. So this approach is rather to clarify those notions, but also maybe in the last part to understand the notion also in the field of the general perception of the effectiveness of legal norms, and whole judicial system as a system consists of legal norms, and the particular citizens as the addressees of those legal norms. So this is somehow conclusion of my speech. So as you see the content, I won't explore everything very deeply, because I would like to really keep my regime, and I'm very poor at keeping regime, so I know that I must switch many of presented issues. So, starting from this part of what was my background, I started to research the theory of management sciences, as well as psychology. This brought me to some core points, and then I skipped to philosophy, and this I must put some assumption, because from the philosophical point of view, criminal procedure must be perceived not as entire entity, but rather throughout the particular action in the criminal proceedings. And this is somehow praxeological point of view. So we must have a close look at particular action, and then as a whole procedure as a construction to be assessed through its goal. So of course we have some connection of the core notion of effectiveness, and I must also add that my inquiry were based on English language. It's important because, for example, in Polish we do not have similar collection of terms. We could use effectiveness in term efektywność, or efficiency in term wydajność, but we do not have efficacy as an additional term. And I think that when inquiring other languages, we must also observe some interferences through those terms that must be adhered to whole discussion. So this point was quite easy to be taken, as many works on management in science, economic works are presented in English, so the same with philosophy and psychology. So first of all, just some highlights about the economic theory of effectiveness. So this is nothing to be very new. First of all, we might take from those theory two distinctions. The first one, which refers to distinction between the goal-based theory and systemic interpretation of effectiveness. From this angle, we will proceed with the first option, the goal-based theory. So as we could read here from my paper, the goal-based theory put an accent to the purposes, the goal, which is quite natural when analyzing criminal justice, and I already settled this assumption. Then the systemic perception rather create the perspective to analyze the process as a whole. So maybe this angle also might include some goals, but also the goals which are attributed to the performers, participants to criminal trial. And then I will argue that the goals of performers, participants, to criminal justice are not the same as the goal foreseen for criminal justice by legislator in the continental law system. So according, just to sum up to the goal-based interpretation, effectiveness is understood from the point of view of achieving goals, which might be also understood as effectiveness sensu stricto or efficacy, and which is a result of my inquiry that those terms might be used interchangeably. And then efficiency concentrate on resources used. So this is this economical value, time-consuming value of criminal justice, something that is possible to be measured. And then we have another approach, subjective and objective approach. And this is also very important when perceiving criminal justice. Why? Because we never ever might apply those economic theory in objective way. It is always subjective way of application. It means that criminal justice is impossible to be measured in the sense of economics. So always if we would try to attempt of the use of some economic theory, this is always subjective approach, which is somehow just general estimation of different values that must be combined in criminal justice. So this part might be taken from this economic assumption. Then I'm researching in my paper just some highlights, the psychological approaches, which also might be interesting when it comes to some selected legal actions and the whole process. Here I'm concentrating generally on passing judgment and action by the court, which might be efficient because through this action, the whole process is observed. I mean, when we regard the activity of participants in the trial, legal action, as Dr. Zora said, instrumentalization, abuse of law, all this is referred finally to the judgment, the final decision. So efficiency of the decision process, it's also some core pivotal part of discussion about the effectiveness. So this is approach which I'm giving in relation to collective actions and also passing judgment. This I will skip because it is quite a broad approach, and today I would like to concentrate on some philosophical point of view given by a very fine Polish scholar, philosopher, whose name is, probably you know, the Polish students and researchers, and I hope some researchers from abroad also have heard about Tadeusz Kotarbiński. And he presented his work entitled The Treatise on a Good Job, which is about the pure praxeology of action. And he operates on the notion effectiveness, efficacy, and efficiency. And this approach has been attributed to particular action, which is perceived, well, from a very close perspective, but also as an action in a course of action. So this perspective must be taken somehow as a perspective to observe criminal justice. And in Kotarbiński's works, we see that effectiveness is a part of a more generic property of action, namely efficacy. So in his work, efficacy is a term broader than effectiveness, because efficacy covers every praxeological value of action. What does it mean, value of action? Also, the value which is negative sometimes. It mustn't be positive. It mustn't be the value program for criminal justice. Sometimes this praxeological value is connected, for example, with the action of defense, which is against the goals of criminal justice, which is instrumental sometimes to postpone the hearing, to make the justice longer, make the justice more expensive. All those goals might be seen as a part of the concept of efficacy by Kotarbiński, because Kotarbiński observed action as a rational activity of a given subject. And for this given subject, the abuse of law might be sometimes perceived as valuable for this particular subject. I'm so sorry. And also what is taken from the Kotarbiński, and that might be used for interpreting effectiveness in criminal justice, is that, first of all, this assumption that efficacy in this particular attempt is broader notion, as I said, and then that somehow operational and synthetic efficacy must be described. So the former, so operational, is semantically equivalent to the skills, And the latter embraces all the practical values that can be reasonably ascribed to an action, such as precision, economy, simplicity. Of course, those are denominations not only for the legal actions, but generally for action of the subject. And based on this theory, because this is quite broad background to be described, I'm trying to adhere what is important to interpret the process as a whole and how we might jungle with the particular goal of actions given by the particular participant to the trial and the whole effect, I mean the whole process and the whole final decision in the given process. So then, of course, because it is my somehow baby in research, I also had a look on the CER's conception, namely conception of constitutive rules, and just I would like to mention that based on CER conception, we might distinguish the effectiveness in the sense which is normative sanction or normative consequences of the given action, as well as effectiveness as the notion in praxeology. And this is for now, it is enough because this is somehow clarification how to perceive the effectiveness also just in pure normative sense. Effective, non-effective, which I use the term as a legal negative consequence for the breach of rules to perform legal action. Okay, and this just to show you what is in the paper, and when it comes to the legal perspective, we generally base on what we understand and we use in our language. So we use those notions somehow intuitively. And first of all, we use those notions from the dictionaries. And also based on references to the dictionaries, one should define effectiveness as the ability to achieve what you want. And efficiency is the level of performance. So you see the difference, what is the second one is possible to be measured somehow, so be used in this sphere of evaluation, shortened procedure, aspects, somehow negotiated justice, even somehow restorative justice tools in criminal trial. So what is important in criminal, in legal analysis is also that we speak always about the efficiency, effectiveness to somehow part of activity, as I mentioned at the beginning. What does it mean? It means that this perception is firstly complex, but secondly, sometimes what is sometimes confusing, I must add, this complexion of effectiveness sometimes might be confusing because it's referring to a specific legal terms. And we have examples, and I'm discussing also in my work the example of the legal, the use of effectiveness, efficiency in a legal sphere by a legislator, especially based on European examples. I mean European because based on treaties, so Article 13 of the European Convention on Human Rights, Article 19 of the European Union Effective Remedy, as well as Article 47 of the Charter of Fundamental Rights, when we discuss the right to effective remedy. In my paper, I made also references to some work by other performers, because we have some work in the section Effective Remedies. So how we might describe effectiveness based on those systems of remedies. We discussed the remedies for a whole trial, as well as the system of remedies for particularly evidentiary actions. So these might be also somehow added value to the perception of effectiveness. The level of references, the supranational level, gives us something more. As Professor Taiman today said, when we discuss about the criminal procedure, and from this external point of view, international point of view, we concentrate on value very often, because in all European conventions, international conventions, there are many things about the value. This perspective is defendant-oriented, rarely victim-oriented, but never oriented on substantive justice, for example. So why do we discuss those issues? So what is the perception of effectiveness in criminal trial when we had a look through the goal for criminal trial, and where is the place of substantive justice? And where is the place of substantive justice in relation to the rights of defendants? Because obviously from the point of view of the European Convention of Human Rights, right to defense prevails highly over the right to recognize material truth. But what is based on national regulations? For example, Polish Code of Criminal Procedure presents us approach that material truth is still an objective of criminal justice. So my question is whether this perception creates us some optic for effectiveness, and who is under the charge to discover this substantive truth in criminal justice, because obviously not someone who is not under the burden of proving. So the fact. Okay, I proceed to the end, of course. So all this is in my chapter. So I hope I just could bring your attention to this chapter, and I would like to just say one more thing at the end, which I think is relevant as a conclusion. That my perception of effectiveness of criminal justice must be seen also from external perspective when it comes to the creation of law, and this means active and fair participation of private participants in criminal proceedings, as well as so-called social participation, which means democratic legitimization of criminal justice. Thank you very much for your attention.
Thank you very much, Barbara. That was really a lot of theoretical work that actually lies as fundaments for our discussion today. And the next speaker will be Professor Daniele Vicoli from University of Bologna, who will be speaking about effective justice between efficiency and guarantees. And he will say how the concept of effectiveness should go beyond a verification of the optimal functioning of the system, how it must be understood as an expression of the optimal relationship between the objectives and the means to achieve them. And I hope it will be exciting. But the floor is yours.
Thank you very much, and let me thank once again all the participants to the conference. I appreciated a lot all the presentation. I will address, I'd like to address a topic very connected to that one of Barbara's presentation. I don't know if it's the best moment, because the topic can be defined as the treble E topic, effectiveness, efficacy and efficiency. My approach will be more theoretical from a certain point of view, and so maybe if I had listened to Barbara's presentation, maybe I would have changed some aspects of my analysis. However, this is the summary. I go very fast. Foundation of criminal justice system, fundamental rights and public interest, so possible clash between guarantees and efficiency, effectiveness from the philosophical concept to the relationship between with efficacy, efficiency through the lens of economic analysis of law, the due process clause as the key parameter to evaluate effectiveness.
in the context of the analysis that are directed at outlining the foundation on which a criminal justice system must be built, one of the most controversial and debated issues concerns the balancing of the various interests deserving protection. In this slide, you can see the traditional approach to this topic. The premise is that the criminal trial must be attributed the function of guaranteeing the defendant. Recognition of the right to personal liberty implies that means of protection are provided with respect to the activities of the public authorities aimed at ascertainment crimes. So these perspectives highlights the relationship that links the inviolable nature of personal liberty and the necessary provision of adequate guarantees. In this sense, the right to judicial protection must be included among the fundamental rights of the individual. And so this is the first interest. At the same time, it cannot be denied that the trial is the means by which the provisions of criminal law are implemented. Consequently, the legislator, when laying down procedural rules, must also take into account the need for the ascertainment of crimes. And this is the second interest. In this respect, there is a widespread tendency to consider that the state's interest in punishing the perpetrators of criminal conducts find expression in the value of efficiency. Such idea is further developed in a logical scheme that sets guarantees and efficiency in opposition. So, in particular, this way of reasoning, with a view to ensuring a reasonable balance between the different interests into play, assigns to the efficiency the function of limiting the expansion of guarantees, which might otherwise grow and grow to the point that the process cannot go ahead. It has been suggested, however, that this approach should be superseded by a different idea of efficiency. Efficiency as a value that is to be related not only to the public interest in fighting crime, but more generally to all the objectives underlying the criminal justice. So, efficiency, in this perspective, is a necessary condition to make the criminal justice system effective by taking into consideration all the interests and needs that qualify the criminal procedure. The advantages of this approach are easy to understand. If efficiency is related to the overall purposes of criminal justice, its implementation is instrumental also to the strengthening of guarantees, according to a pattern pursuant to which implementing efficiency would mean implementing guarantees. This approach reflects the idea that efficiency is a necessary condition to make the criminal justice system, as I told, effective. Of course, the concept of effectiveness is not easy to define. In the field of legal philosophy, effectiveness refers to norms. A norm is effective if it is observed or applied. This definition is useful because it highlights that effectiveness is a gradable concept according to degree of compliance. This is a good starting point. However, for the purposes here, a further step must be taken. The concept of effectiveness must be considered in relation to another criterion, efficacy. The reference is not to the technical legal notion of efficacy, I mean the attitude of a rule to produce legal effects, but to the philosophical one, according to which a rule is efficacious if it fulfills the purposes for which it is intended. And in English, the words, the adjective effective is used in both sense, effectiveness, but also efficacy. For this reason, I used efficacious, a word that I don't like because it doesn't sound very well, but it needs to distinguish effectiveness and efficacy. Traces of this approach can be found in the jurisprudence of the European Union Court of Justice. Effectiveness is the very soul of legal rules, and therefore is not excessive to say that any legal rule must be at first sight presumed to be operative in view of its object and purpose. And a similar approach can be found, has been developed within the system of the European Court of Human Rights. In many occasions, the importance of the principle of effectiveness as an interpretative criterion for conventional provision has been stressed. The rights provided for the conventional provision must be of practical and effective use. So, understood in this way, effectiveness can also be examined according to reasoning models based on economic analysis of law. Studies of this kind consider efficiency as the key parameter of evaluation and selection among different regulations of a certain phenomenon in order to find the regulation that produces the most efficient results. Rules, in this sense, are conceived as mechanisms for allocating limited resources. When talking about justice systems, efficiency concerns the relationship between the aims pursued and the means employed to achieve them. From this point of view, a rule can be said to be efficient if there is no way of fulfilling the aim with less expensive means, or if there is no way of fulfilling the aim to the higher degree using the same means. What does it mean? A rule can be able to produce the intended result, but can be excessively costly. It means that the rule is efficacious, but is not efficient. On the other side, a rule can be able to produce the intended result in the most advantageous and resource-saving way. It means that the rule is efficacious and, at the same time, efficient. When applied to criminal proceedings, the economic theory must be considered with great caution. There is the risk of weakening the protection of fundamental rights, first and foremost the right to personal liberty. However, also in this field, it's relevant and useful insofar as it highlights another aspect of the concept of effectiveness. It has been said that in general terms, effectiveness is a trait of the rules as applied. More specifically, effectiveness must be combined with the parameter of efficacy, understood as the suitability of a rule to achieve the purpose in view of which it is set. In addition, effectiveness must be pursued efficiently. The outcome of the reasoning is that effectiveness must be considered in close connection with the means chosen to achieve the procedural system's underlying purposes. And in this regard, the direction to be taken is very clear. The means must be found in the due process clause as it has been outlined by supranational sources, in particular Article 6 of the European Convention on Human Rights and Articles 47 and 48 of the European Union Charter of Fundamental Rights. The presumption of innocence, the right to confrontation, the impartial role of the judge, the equality of arms, and the reasonable length are fundamental traits of criminal proceedings, meaning criminal proceedings is to be deemed fair provided that these requirements are met. Those guarantees constitute the means for adjudicating the case which are capable of ensuring the effectiveness of the interests involved in criminal proceedings. So, in conclusion, effectiveness cannot be interpreted in bare economic terms, but as the expression of the optimal relationship between the aims pursued and the means, the due process clause, to be employed. Thank you very much for your attention.
Thank you very much, Professor. Your speech was in perfect harmony with the previous one, you have to admit it. Always in harmony. Like it was the next episode of our series of efficient justice for today. And the next speaker will be Dr. Marcin Rau from Cardinal Stefan Wyszyński University, who will be speaking about challenging legal education in pursuit of judicial efficiency, a comparative analysis of Poland and Italy. And he will present, as promised in the title, the integral role of legal education in shaping the efficacy of the justice system. You have 15 minutes and 1 minute more for conclusions.
Thank you. I will do my best. So first of all, I'd like to express my warmest gratitude to Barbara for perfect organization of this event and Daniele for being part of this project, and thank you once again for having me. My colleagues set the expectation bar pretty high, so I'll do my best to live up with your expectations and at least give it my presentation in such interesting way as you already did. Barbara was right about the very complex aspect of effectiveness, efficiency, and efficacy. And one of the things she mentioned was the time management.
Daniele made a point telling about the concrete, real result we'd like to achieve. And I will contribute to the research by adding another dimension of effectiveness. I mean the human factor. The human factor and his skill set. But many of you may ask, how can we measure the skill set of judge, the skill set of prosecutor, or the skill set of the attorney? Well, I assume it all boils down to the legal education, because the ground of our knowledge is the knowledge we gain through our educational system. Unfortunately, some of my remarks might sound very pessimistic. I did my research in Poland and in Italy. And in both those countries, the model of legal education is deeply rooted in 19th century positivist legal doctrine, which reduces law to written texts and marginalizing the practical aspect of application, the knowledge. The legal studies, based on the memorization of the text, lead us to the situation when the law graduates enter the professional area and they have a pretty hard situation with applying the knowledge in practice. But how is possible, you may ask? The main reason is some kind of dichotomy. The academia is creating the lawyer who is a scholar. The lawyer who knows everything, every doctrine, every point of view in many aspects. However, after graduation, the legal corporation, the judiciary, the prosecutor office are creating the lawyer practitioner, and they value the practical application of law, innovative thinking, craft or argumentation, crafting of legal documents. And how can we connect those two dimensions of legal education? Well, the answer is as much complex as the efficacy, efficiency, and efficiency. However, I tried to create some kind of conclusions to present to you the main shortcomings in current legal education system, especially when we are talking about the generation Z, Gen Z. So the students which are born after 1997 and they enter the academia in time of digitalization, in time of ChatGPT and artificial intelligence, and Wi-Fi and knowledge of whole legal world in their pocket, on their iPhone. The paradigm of legal education in academia is a little bit different than the expectations of Gen Zs. And based on the studies conducted in Wrocław and in Catania in last 5 years, we can see the deficiency in effectively connecting the transfer of knowledge with practical implementation and the expectations of the younger and the youngest generation of future lawyers. To make a short definition, let me introduce you the 3 elements which are applicable both in Poland and Italy according to the shortcoming of legal education. Number 1 is the inadequate method of transferring knowledge. Number 2 is neglect in instructing new essential skills. Number 3 is mismanagement of time allocated to given subjects. But in order to avoid potential misinterpretation of my words, let me examine the following. The first thing which the youngest generation of students and future lawyers find very difficult to comprehend is the passing learning paradigm. The passing learning paradigm places a great emphasis on the memorizing the information and the reproducing the facts rather than the comprehensive understand and utilization of knowledge. Active learning, in clear opposition to passive learning, requires students to think critically, to analyze the facts, to show their statement on central matters. Passive learning, as Professor Aleksander Marsawelski yesterday made a point, might be illustrated with the example of swimming class. Imagine a swimming class after which you are expected to be swimmers. You cannot swim. You go to the swimming class, you stay on the edge of the swimming pool. The swimmer, the teacher, and jumps into the water and is telling the students, I will show you how to swim. And he's swimming freestyle, he's swimming backstroke, he's swimming butterfly style, and he's telling to the students who are staying on the edge of the swimming pool, I will show you once again how to swim. And then, after 100 meters, he left the swimming pool and said, okay, in the next week there will be a test of swimming. But the test of swimming will be theoretical, so you will not jump into the water, but you will have the written assignment of the theory of the swimming. And in Professor Marsawelski's example, we can see the disproportion of academic theory of swimming and the practical aspect of swimming, which is a metaphor of applying law after academia, when we enter the corporation, when we enter the prosecutor office, and when we enter the judiciary. Another aspect, which is also under huge critique of young generation students, is the omission of new skills. In the world of artificial intelligence, in the fake news and deep fakes evidence and AI-generated pictures and videos, selective information proceeding would be something what the new generation students would like to know. Critical thinking and mindfulness skills are welcome. Soft skills like rhetoric, negotiations, or stress and time management are also something which even after graduation and even entering job market, the students don't have. That's why many of you, after graduation and entering job market, may feel lost because the future employer will demand something you never had about it. You didn't know, and nobody taught you. And the last thing which the students would appreciate is the transformation of some subject during the legal curriculum. I did the study in the last 3 years in Kardynał Stefan Wyszyński University in Warsaw. I made a survey asking 333 students from the third year about the legal preferences and which subject they would prefer to learn more and which subject doesn't correspond with their interests at all. And I will bring one of the results of my study, namely the history of law. Of 333 students, 270 admitted they don't have any interest in legal history at all. 27 participants admitted they have the high level of interest and 75 moderate interest. Moreover, the students in almost the same proportion said they would prefer to have bigger influence on the subjects they can choose for their choice, which correspond with their interest, instead of have obligatory subjects. By telling about obligatory subjects, according to my study, students prefer to have more classes in civil law and criminal law and procedure. This is unusual outcome, but it was the preparation of the youngest generation of lawyers. And in my conclusion, we shouldn't just get rid of the philosophy, Roman law, or history of law. We just should give the students, especially in the generation Z, possibility to choose, to tailor their program of studies to create the better teaching and learning opportunities. Maybe many of you would say, oh, those proposals are pretty impossible to make it. But in my paper, I explore the offer of common law countries, especially with the University of California, Berkeley, when the applying knowledge by experimental learning. The first year student can enter the legal clinic and without preparation, they can learn by applying law in practice. To sum up, I hope that the question of changing legal paradigm is not how, but when. And we, as the scholars, have this power every day when we enter this classroom. Thank you very much for your attention.
Thank you very much for this interesting perspective. I'm sure many professors from older generation won't share your perspective, though. But it's interesting to have many perspectives in our world. Obviously, we are really interested in the effects of your proposal. And the next speaker for today is Tomás Manguel from University of Buenos Aires and University of Palermo, who will be speaking about the aim of who will be exploring the impact of universal jurisdiction's application on the principle of complementarity before the International Criminal Court and the interaction between both under this new paradigm that he will be discussing. Please, the floor is yours and you have 15 minutes.
Hello everyone. Thank you so much. I'm thrilled, I'm happy to be here among all of you. Thank you to the participants. Special thanks to the head of the project, Professor Vicoli, and special thanks to Professor Janusz-Pohl for inviting me and having me here. And thank you also to my esteemed colleagues. It was a pleasure to listen to all of you. So The idea for, sorry, let's put then 15 minutes plus 1, right? That's what we have. Okay, I will keep that in mind. So what I would like to address today, first of all, I would like to just 1 minute to speak about actually what Martin was just saying. I'm Argentinian. I'm professor of the University of Buenos Aires in Argentina. I'm a Jewish Argentinian, and I have Polish roots. My grandfather, from my mother's side, he was born in Łódź, and then he fled to Argentina due to the war, and he lost all his family during the Holocaust. So it's quite moving, and for me being here in Poland, it's my first time in this country. I've been all over the world, I would say, but it's my first time here, so thank you again, Barbara, for encouraging me, and thank you, Michał, also for all your help for coordinating this. What I wanted to say also about what Martin was saying, in the case of many Latin American countries and Argentina, this is not regarding my presentation, I'm sorry, but I will go back to that immediately. At the age of 17, I started studying law at the University of Buenos Aires, and at the same time I started working at a law firm. And after 2 years working at the law firm where I was studying at the University of Buenos Aires, I started working at the judiciary in different instances until I achieved to become a senior legal officer at the Court of Cassation, which is the highest court in criminal matters. And during all this period, I continued my studies. I did 3 LLMs, once in Torino, where I met my current wife. She's Turkish, and that's why I'm living in Ankara now. And after that, at the age of 44, now I'm pursuing my PhD for the first time. So I see many of you academicians who are very young. At the age of 28, you have a postdoc, which is really impressive. And that's also the thing, when you do both things at the same time, it's quite difficult to find the balance between becoming a practitioner and also an academic, so you struggle a lot. But at the same time, it's also true that having the knowledge and experience of working, you can also understand the challenges of law in practice, and then that sometimes would be helpful in order to do your research thesis. So that's also why now I'm doing my PhD in Palermo. So as I said, I was born in Buenos Aires. My grandfather escaped from the war. I was born in 1979 in the midst of the so-called dirty war in Argentina, where 30,000 people disappeared. So of course, with this combination between Holocaust and dirty war, I could not pursue any other career than law, and in particular international criminal law. What I would like to speak today has to do with the mechanisms of international criminal justice to pursue justice and to try to find this ideal of an effective justice. We could say that there are different stages, usually, of the evolution of international criminal law, starting from Nuremberg and Tokyo tribunals. Then in the 90s, with Rwanda and Yugoslavia, we have the ad hoc tribunals created by the United Nations Security Council. That would be the second phase, I would say, of the evolution of international criminal law. Then some kind of bridge of hybrid or internationalized tribunals like Sierra Leone, we can mention Lebanon, also Timor-Leste, and so on, until we achieved in 1998 the adoption of the Rome Statute in July, which became into force in 2002. So I would say those are more or less the different stages of international criminal law. But I believe that now we are in a very interesting stage of international criminal justice due to what happened after the Russian invasion of Ukraine 2 years ago. We saw that new mechanisms are emerging in order to provide states effective tools to prosecute international crimes. We are seeing very new mechanisms which were completely unusual from Nuremberg until now. We can speak about the Joint Investigation Team of Eurojust and the International Criminal Court, also cooperation agreement of the United States, which, as you know, it's not a signatory state of the Rome Statute, and regardless this, they signed an agreement in order to gather evidence. The Ljubljana and the Hague Convention, which is a unique convention, which is not only a convention of mutual legal assistance for the most horrible crimes, but also gives the obligation of signatory states in order to criminalize these international crimes in their domestic legislation, and also provides this odere or judicare principle, which is some sort of universal extradition, but I will not enter that into that. But in particular, what I think we can see after the war in Ukraine is the new stage of renaissance of universal jurisdiction cases, which also established a new specialized units between the different war crime tribunals in order to prosecute these international crimes. So this is something absolutely and completely new. But what's happening here? Of course, universal jurisdiction didn't see the light only 2 years ago. They have come tracks back to certain years. We can say that the peak was in 1998 with Pinochet arrest warrant, actually the same year of the adoption of the Rome Statute. But for sure, what is happening in the last 2-3 years is this a rose of cases, what I call the renaissance of universal jurisdiction. As you can see, here is the last report of Trial International. This is a Swiss NGO that tracks the cases of universal jurisdiction. You can see that there were in 2003 84 universal jurisdiction cases worldwide, an increase of 33% since 2022 after the war in Ukraine, and over 150% increase over the past years. Many things that would be interesting to address, but I won't have the time. But one open question that I leave is, are we before a new trend of prosecution of international crimes? Is the future of international crimes a domestic one? What about the ICC? What's going on? But because in theory now we have a permanent court. And why we're having this increase of prosecution of international crimes domestically? Is it because of the shortcomings of the ICC? And this brings the question of effectiveness. Is the ICC effective or it's not effective? If you can think in these last years, in these last 22 years, there are almost 30 cases, 10 convictions, 4 acquittals. I mean, is that shortcomings or no? If you compare with, for example, the ICTY, where in 25 years' time, they indicted 161 people and they convicted 80, almost 50% of the indictees have been convicted. If you compare both of them, it looks that it fell short. But is this renaissance of universal jurisdiction? It's due to that. And this brings one of the other concepts that I want to address to you, which is the principle of complementarity, and try to think how they interplay between universal jurisdiction and the principle of complementarity of the International Criminal Court. When the ICC was created, this principle was the most important tool mechanism of the ICC, which was the principle of complementarity. It says the main responsibility to prosecute these crimes remains on the state. The states are the ones who have to first try to prevent these crimes to be committed, and secondly, they have to prosecute these crimes. This idea of responsibility to protect was afterwards in 2005 recognized by the General Assembly of the United Nations. So the main responsibility to prosecute these crimes are the states. And if the states do not do this because they're maybe unwilling or unable to do it, then the ICC steps in. Because of this, when the ICC was created, its first prosecutor, Moreno Campo, said, actually, the less cases we have speaks about the efficiency of the ICC. Because the idea of the ICC is in order to help the state with what it was called proactive complementarity to investigate this case. So if we don't have cases, that speaks wonderful about us. It means that we are doing our job correctly. So, very fast, what do we understand by universal jurisdiction? Basically, there are two grounds for the exercise of jurisdiction in the national and in the domestic tribunals. The territorially, which means that the crime was committed in the state, and that's why I have jurisdiction over the crime. And then I have extraterritorial principles, mainly the active personality, the passive personality, and universal jurisdiction. This means that universal jurisdiction is a form of extraterritorial jurisdiction. It's the ability of a state to prosecute a crime regardless any link with that crime, regardless where the crime was committed, regardless the nationality of the perpetrator, and regardless the nationality of the victim. It's important to also note that universal jurisdiction has also served as a catalyst of fight against humanity. There's many cases, but one of them has to do with the famous Madrid trials, the Argentine case, or also even the Pinochet case. They were all in the same case before a Spanish judge, Baltasar Garzón. And in particular, during the 90s, there have been impunity laws. I don't know if you watched the movie 1985, the Argentina case, but after that case, and after everyone was convicted, there were a period in the 90s of impunity laws. So during this period, the only way to pursue justice was not within Argentina, but other jurisdictions. And this is why the case was brought before Spanish tribunals in the case of Silingo. And Spanish tribunals first confirmed universal jurisdiction and even convicted Silingo. Also, Silingo is a person who confessed the crimes, and he said that the people, after being kidnapped and tortured, they were being dragged and taken into planes, and they were thrown to the river where they were finally killed. This was Silingo, who was convicted in Spain. And Spain said that they will continue to exercise extraterritorial jurisdiction unless territorial justice effectively recovers its jurisdiction. It will maintain its jurisdiction unless impunity laws are definitely annulled in Argentina. And look how immediately after the Supreme Court declared impunity laws null and void and reopened in 2005 the cases. Now we have more than 1,000 convicted for crimes against humanity and crimes against humanity in Argentina. Regarding the principle of complementarity, on the other hand, as I said, it seems that the ICC, in order to exercise its jurisdiction, has to demonstrate the failure or inadequacy of the domestic judicial system. Only if the ICC can check that the crime is not being investigated in a country because it's unable or unwilling, then the ICC will step in. This is a very interesting thing, the following one, but I will not have time to address, which is what happens if the country is conducting all these investigations, it's prosecuting, it's convicting, but not in observation of due process of human rights. For example, what happens in Ukraine, even with the fair trials conducted against Russian soldiers. But I will not enter into that. So, what I want to address here is when the Rome Statute speaks about the principle of complementarity in its preamble, it says affirming that the most serious crimes must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level, right? Then it says, recalling that it's the duty of every state to exercise its jurisdiction. As we said, the primary responsibility relies on the state. But the question here is, which states are we referring here? Are we referring to the affected states, meaning are we referring to the state where the crime was committed or where the perpetrator is a national one? Or are we referring to any state in the world that could exercise universal jurisdiction? So these are two different theories with different outcomes because it defines who is the ultima ratio. Is the ICC or is a third state exercising universal jurisdiction? And when you assess who is the ultima ratio, you also at the same time are answering to the question, then who has the primary responsibility? So we can say that this is clear, according to the preconditions of admissibility of the ICC, that the ICC can only exercise a jurisdiction regarding crimes committed in the territory of a state party or by a national of a state party. So that's the only way that's why in the case of Syria, there's no case before the ICC, for example. This is, we're leaving the exception of the cases referred by the Security Council that they don't need to meet these requisites. But besides the case of the Security Council, these are the preconditions for admissibility. But then it says that the court shall determine that the case is inadmissible where the case is being investigated or prosecuted by a state, unless, as I said, it's unwilling or unable to conduct an investigation. And here comes the two different theories if we follow one or the other thesis. If we understand, but as a state, we refer to the affected state, then in the case the affected state is unable or unable, then the ICC will step in and exercise its jurisdiction. And if the ICC does not investigate because it's unable or unwilling, or due to political constraints, like the case, for example, of Syria, or some other cases that have been closed in the case of Colombia, I don't want to enter to the case of Palestine or of Israel because it's complicated, even though there's already an investigation going on, we can say that then the third state exercising universal jurisdiction can step in. So the question here, are we before a second type of complementarity? On the other hand, if we understand that it refers to any state, it means that if a state where the crime was committed does not investigate because it's unable or unwilling, then any state of the world should exercise universal jurisdiction. And if these countries all around the world are unable or unwilling, only then the ICC shall determine that the case is admissible. So the ultima ratio will be the ICC. So in order to conclude, I think that now that we have a new actor, which is the third state exercising universal jurisdiction, it's very important to understand how will this new actor will interplay with the Rome Statute. So thank you very much for your time, and that's it. Thank you.
Perfect timing, especially the speech with conclusions. It's an interesting coincidence that actually today in the morning Polish NGOs documenting crimes committed in Ukraine had a meeting with Challanges International on the topic of how to make Poland exercise universal jurisdiction, because Poland has never used universal jurisdiction and is not using one in Ukrainian cases. It's using protective principle jurisdiction. So it's just a small comment on this topic. And the last speech for today, the last presentation, will concern assessing judicial systems through the prism of their effectiveness and overview of performance indicators. And Michał Wawrzyńczak from Adam Mickiewicz University will tell us whether to adopt universal approach to systemic evaluation of criminal justice or an individualized approach. And you have less than 15 minutes.
5 minutes more. Thank you, Professor Kuczynska. I will start the timer right now, but of course I cannot proceed to the proper part of the speech without thanking the two heads of the project for funding and for leading us all along the way for almost 2 years. Throughout these 2 years, we met a lot of colleagues who are with us here today or will be with us tomorrow remotely or have already delivered their speeches. We have met many of them in person. These ones that we didn't have the pleasure to meet in person yet have arrived here, so we are extremely excited that we had so many opportunities to collaborate together. And of course, I would like to thank on behalf of the organizational team to our moderators, so Professor Kuczynska and Professor Galiński that have moderated before, Professor Filipkowski who has moderated online. It was a great honor and great pleasure to have you here and to listen to all of the insightful remarks that you have had or will have during the discussion, for which I will have less time than anticipated. But proceeding forward, today I have a very simple presentation which will not discuss in reality the criminal proceedings as a whole, but rather I will discuss the judicial systems from the organizational perspective. And I was quite intrigued by my own contribution when I was reading the contributions of the other performers of the project that have submitted their chapters for the common book, which is in the publishing house at the moment, and especially the presentation by Marcin, because it was touching the legal education, and surprisingly the aspect of legal education will also be included in my presentation, although I did not think about this before when I was preparing the presentation and when I was preparing the chapter, but this plays a vital role in assessing the effectiveness and the performance of judicial systems according to one of the performance indicators that was developed by the United nations. So without further ado, when we talk about the indicator, we are talking about some specific characteristics through the prism of which the analysis is made and evaluating the value of these parameters is occurring. So when we have an indicator, it helps us to understand to what extent the system is being effective or ineffective. And in conjunction with just a mere indicator, so a simple tool that is helping us understand the system as a whole, we create the whole system of the performance indicators, which later can serve for a very handy assessment, evaluating tool for people that later will be responsible, for example, for recommending the lege ferenda changes and enhancing the quality of judicial systems. We have to understand that judicial systems, especially in the criminal areas, can take different models. They can be mixed with the advantage of the inquisitorial element. So, for example, the Polish legal system, or they can be more adversarial, like the Italian legal system. But all in all, we still are part of the international organization, which is the European Union, and somehow we have to operate within the boundaries of the European Union. I will touch this issue slightly a bit later, but what else I would like to refer to at this point right now is that there are different metrics for evaluating performance of different branches of the judiciary. Because not every judiciary and not every legal system shares precisely the same values upon which we have to assess whether a system is effective or not. Because in the civil proceedings, which create us the lower standard of protecting the rights of party of these proceedings at the expense for the swiftness and for the pace of the proceedings, we will have different evaluating metrics upon which we firstly want to include whether a party had been entitled to an effective remedy and also have been subject to a swift judicial proceedings. But in the sphere of the criminal proceedings, for example, the pace is less important compared to the civil proceedings, but the effective protection of the procedural safeguards, so namely fundamental human rights, will shine in the scope of criminal proceedings, contrary to the civil or administrative proceedings. So every criminal justice system has to implement the minimum standards and minimum fundamental human rights, which will include the directives upon which we can limit the effectiveness of judicial systems at the expense of protecting and securing the procedural safeguards, for example, the right to legal aid, to defense counsel, or to an effective remedy, or to be present during the trial in certain situations that are legislated on the national level across European Union or any other international organizations. So making this slightly complicated but lengthy introduction that is also highlighting us why we need to monitor the effectiveness of judicial systems. In terms of criminal proceedings, in this example, we have a very visible contradiction. Do we prefer to premium the effectiveness of criminal proceedings, or do we prefer to value more the effective safeguarding of the human rights and of the procedural rights of the accused or any party to the proceedings? So the second question that arises here, what is actually more important? Is it the jurisdiction of international tribunals or domestic courts, or, for example, the international organization's supervision? Because the effective implementation of procedural safeguards, or, for example, assessing the effective judicial system, can also come through the system of the protection of human rights. So, for the countries that are party to the European Convention on Human Rights, we can, for example, argue that an effective system is a system which has low number of infractions of the European Convention of Human Rights, but at the very same time, the length of the proceedings on average in that member state or the party state to the convention can be very long. So therefore, from the point of view of assessing the effectiveness of the proceedings through the lens of its time, we would say that a system could be ineffective and requires to be reformed. But at the very same time, through the prism of protecting the human rights, we would say that this system is extremely effective because it doesn't cause many infractions of the standard that is the main safeguard that we are looking to preserve and secure. So if we also would like to include the assessments made by the international bodies, so for example the European Union, and I will bring a few of the examples. I do not have them on the presentation because it would be too long, but I will only briefly refer you what kind of indicators are assessed through the European Union Effective Justice Assessment Interviewing Toolkit. We have completely different areas than the ones that are recommended by other organizations or other international bodies that are creating such assessment toolkits. How could we measure the effectiveness of judicial systems? Firstly, as I said, to the indicator that is later connected to the performance indicator. These definitions you can read on the slide. Given the fact that I have to keep the time regime for Professor Kuczynska, I will skip the definitions part and I will go straight to the examples of the assessment toolkits. So the toolkits that you can see is the one that was developed by the Vera Institute of Justice, and in my opinion it was one of the most interesting toolkits for assessing the judicial effectiveness or assessing the system as a whole. And I have chosen the table that refers to the legal aid because it is very easily comparable with the United Nations Office on Drugs and Crime, who also have developed a universal criminal justice assessment toolkit, and I will present it in the next slide. So if you would take a look at this example, we have three institutional outcomes that we have to strive for. This is more responsive and continuous representation, greater protection from harmful punishment, and improved confidence in and satisfaction with legal aid. According to this particular toolkit, if we would note an improvement in these three areas, we would say that the criminal justice system has gotten more effective. The potential indicators that would prove that this change has occurred are as follows. The change in the average time between arrest and first contact with legal advisor or attorney. The change in continuity of representation, change in amount of time legal aid clients spend in pretrial detention, change in the number and average length of prison sentences, insatisfaction with services among legal aid clients, and professional reputation of defenders. So these 6 indicators would prove that this particular end goals, the institutional outcomes that we are striving for have occurred positively or negatively. So the quality of the system has improved or degraded. And the possible data sources upon which we can actually measure the potential indicators could be the data, could be the client survey, and the exit service of accused persons, for example, or peer assessments when we are talking about the reputation within the professionals providing the legal help. So this assessment toolkit is in theory quite simple, but compared to the United Nations assessment toolkit, which will take me 3 slides to go through, so I will not discuss it very in detail, but I will just leave you for a second so you can read the amount of sources and the topics that you can look. There are actually 4 main areas upon which we are looking for assessing whether there is a progress in the effectiveness of criminal justice system regarding the access to the defense counsel and legal aid, and those are the following. Firstly, the data and the right to counsel and legal framework. Secondly, the access to legal defense services. Thirdly, criminal defense lawyers. And 4, partnerships and coordination. So as you can see, these topic areas are quite broad, and within these 4 topic areas we have a plethora of instruments that are actually helping us to assess them thoroughly, but then look at the amount of sources that we have and also the contacts through which the assessor of the criminal justice system has gone through to produce a proper result of that assessment that is being conducted. So if you can, for example, look at the section number 4, so criminal defense lawyers, the metrics that indicate whether there was a positive or negative change is, for example, private representation, so the amount of the participation from the office and from the appointment by the private party. As you can see, points 1 and 4.1 and 4.2. The contractual lawyers, point 4.3. Legal aid and public defender service, point 4.4, and legal assistance by non-lawyers 4.5, along with adequacy of representation and challenges to effective representation as points 4.6 and 4.61. So just for this one metric, we already have 6 factors that we have to include in order to assess whether the positive or negative change has occurred. Compared to the Vera Institute of Justice that had only 4 indicators and very simple metrics of assessing this, this is much more complicated, much more detailed, and perhaps much more effective tool in terms of providing and producing the results for a positive change. But going to the part of Marcin that he has touched, if I could ask for your attention on point number 5, so criminal defense lawyers education, admission to the practice of law and training of the lawyers, this is actually one of the metrics that includes, and this is coming from 2006 already, when the emphasis was put on the quality of defenders rather than just the mere accessibility of defense, that we actually have to supervise not only the professional training already of those who are in the bar, but also of the legal students to shaping their practical skills. And I agree with Professor Kuczynska that many of the refined and distinguished and older professors would disagree on that paradigm change completely. But I think that in addition to the theory of law that we have to provide for the students and that we have to teach, we also have to include clinical legal education or practical classes on which the change, the positive change that we are discussing right now could occur, and we could have a really smooth collaboration on this one. But I hope that you will continue your research on this because it was extremely interesting. What I want to underline when it comes to these 2 metrics, because those are just 2 propositions, and I know I have to wrap it up, so I will be proceeding very smoothly. As you can see, there is a broad area in which the manipulation of the statistical data can happen. And this can merely come from the selection of the topics that we would like to improve on and the selection of the sources upon which we will have an assessment. So, for example, how to assess if the prosecutorial service is effective. 1, we can factor in the amount of cases that went to the trial and the amount of victories, so the convictions that the prosecutor has obtained. But on the other hand, we can include all of the cases that were brought to the in personam phase, so where the charges have been brought to the suspect even before he became formally accused, and then if the charges have been dropped and case have been dismissed, the amount, the percentage of the cases in which the prosecutorial services have diagnosed the suspect properly would be certainly slower or lower than the 90% that we have right now under the conviction rates. So when we talk about the individual or universal approach, as referring back to the topics that we had, we can have parties to the international convention that do not feel like they have to universalize or harmonize their legal orders, but in case of these strong ties, the states will just opt into having the individual justice systems, and they can assess them based on the legal tradition that they have. But on top of that, in the organizations that have very strong ties, like for example European Union, we can have a harmonization procedures in which we can actually use a standardized assessment toolkit in order to propose very similar reforms or the same reforms on the organizational level, which actually would solve the Copenhagen dilemma, for example, that the Court of Justice has connected to the rule of law backsliding in Poland and in Hungary. So this could be one of the toolkits that would only not impact the quality of the judicial systems in the short term, but also in the long term. For the conclusions, and if I can just put your attention one more time, the last time on the table that you have here. Of course, this is in Polish, so I will translate it very smoothly. On the left side, you have the years, then you have the amount of cases that went to the trial and the sentence had been handed down. Then amount of convictions, discontinuations of conditional discontinuations of proceedings, the cases in which the judge has refrained from sentencing, and the precaution measures. This last column is not interesting for us. What I would like to ask you to pay attention to is the column of odsetkach, where you have the percentages of cases which ended up in the convictions. So from 2014 to 2018, on average, we had around 300,000 cases each year going to criminal courts, and the amount of convictions in those cases are around 90%. If we include the conditional discontinuations of the proceedings, it comes up to 99%. So in reality, it turns out that if the case goes to the trial, we have the criminal law system in Poland that is effectively flawless, because we almost never prosecute a person that is innocent, in fact. Almost every single case that goes to trial ends up in the conviction, so it seems that our police officers and prosecutorial services are almighty in this regard, because they are always right. And I'm very impressed with this, but I have serious reservation, and I'm extremely happy that Professor Kuczynska is here, because last month in Wrocław, she has touched this issue together with Professor Kardas. Is Poland ready to have lower amount of convictions than 99%? Are we ready to admit that our criminal justice system perhaps is more flawed than this mere 1%, or even if we don't want to factor in the discontinuation of the proceedings, the 10% of the cases that do not end up in a sentence that is convicting the accused in trial in court? Because in reality, as Professor Taman have said, if we have 90% of the cases that end up in the conviction, perhaps the way forward, the only way forward, is using the consensual procedures. But then, if we only have to rely on consensual procedures to stray away from the court, is it really a fair trial that we are talking about? And is really our system prepared for going to such an assessment and ensuring that the legal aid, the system as a whole, and the judiciary is optimized and effective in this regard? So thank you very much. Once again, my congratulations for all of the performance, and my deepest thanks for the 3 years of our collaboration. I hope it was 3 years, first 3 years, and not the last 3 years as well. So as always, we are delighted to have you here, and I give back the voice to our principal moderator. Thank you very much.
Thank you very much for this very speedy presentation. Speedy but very interesting, and there were so many different issues to discuss. I hope that today during the panel we helped the judges to make the justice effective, so that it could still be justice. So efficiency without justice is not justice at all. And let me wrap up with the last joke, because I'm reading a lot the files produced by National Council of Judiciary, where they evaluate the judges, whether they are worthy of a promotion. And I remember one motivation. The 50% of the judges' judgments were annulled, but he was very effective in his job and he gave many judgments. And that's not the way where we should go. Thank you very much for the attention, and I'm awfully sorry, questions must wait till dinner, but we have to close the panel right now. Thank you very much.
Outside for a chat.
Yes, you're free to chat outside.
I have a question for Manuel.